Bigger portion.
Yes,
I would like to mention item number 26, my lord, in which
26.
my lord,
Okay, volume.
in which we filed an affidavit yesterday, my lord.
Yes.
That may kindly be brought and allowed to be brought and be tagged with the matter when the matter is.
Now, one RSF for orders, your lordship,
When?
next week, your lordship.
Okay,
On
take a
9th
date from
September.
here.
May I please, your lordship, with the consent of other side, I beg to mention item number 25, your lordship.
Item number 25.
My senior is out of station, your lordship, so the matter may be passed over for 1 week.
I am from the appellant.
You are for the respondent.
Yes, your lordship. May I please, lordship?
Your good name?
J. Chhetri, Miss J. Chhetri.
Miss Jay Singh.
J. Chhetri.
Jay Setri.
Yes, sir.
Acha. Learned counsel for the respondent with consent from the other side. Press for listening the matter. When?
After 1 week, your lordship.
After 1 week. Okay. After 1. Fair lot.
May I please, lordship? Item number 9, the matter may be taken after 2 weeks.
Which matter?
Item number 9. We have put a respondent number 1 in. We will file the affidavit on evidence on affidavit. Against the opposition.
Your good name?
Anusmita
You are appearing on behalf of?
MP Sharma.
Pardon?
MP Sharma.
Miss, you are for the? No.
Different.
Did you inform the other side? No. You first inform me. Only then we will consider your pay.
May I please, your lordship?
Obvious.
Lordship, with the consent of the other side, I beg to mention item number 24. lordship. The matter may be adjourned for the day, lordship.
24.
24, lordship.
Your good name?
M.H. Ali on behalf of A. Shahad, Mr. A. Shahad.
Mr. M.S. Ali.
Yes.
Learned counsel appearing on behalf of Mr. A. Sahad, learned counsel for the respondent. With consent from the other side, press for listening the matter after
2 weeks, lordship.
2 weeks. Fair lot.
May please, your lordship, I beg to mention for listing MSC appeal number 330/2019.
When?
9 September.
On 10th September.
Then. My lordship, I beg to mention for listing an MSC appeal for any date next week.
When?
Any date?
On 6th September.
Take a date from me.
6. May please, your lordship. Your lordship, with due consent of the other side, I beg to mention item number 19 of the daily list, your lordship. There is
Item
some-
number 19.
Item number 19. There is some difficulty on the part of the assisting counsel, your lordship.
Pardon?
There is some difficulty on the part of the assisting counsel, your lordship.
Acha. Your good name?
And Mahanta.
Learned counsel appearing on behalf of Mr. Ken Chaudhary.
Plain short.
Learned counsel for the appellant. With consent from the other side, press for listening the matter after
Any date, your lordship.
On 16th September.
Deeply obliged, your lordship.
I beg to mention lordship listing the matter for urgency.
when?
After
On
After
13th September.
If I may please, the lordship, I beg for listing a matter for order. It's a long pending case. It's an appeal of 2013 matter. The matter may urgently be taken by next week.
when do you want?
By next week or any convenient day.
On 2nd September.
May I please, lordship? I beg
Yes.
to mention item 30 matter. I want to withdraw on instruction.
13.
30. 30 matters.
You want to withdraw?
My lord,
Item number 13.
my lord.
This RSA.
No matter, item number 30, 30 matter.
Oh, 30.
Stay matter.
Mr. A. Sigdar.
SA Sikdar matter.
S.A. Sigdar, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Accordingly, here is allowed this
Interim
petition
order may be
stands
vacated.
disposed of on withdrawal.
Interim order may be
Liberty.
vacated. Interim order may be vacated.
Interim order pass earlier. Interim order, if any, pass earlier stands vacated. Whether liberty will be required? Not required.
Top of the list item number 32.
Yes, please, lordship.
Yes.
So in this case, I am challenging the order dated 23/11/2023, whereby the learned court below has proceeded the matter ex parte against me.
And I was not given the opportunity to filing the written statement. And the lordship, the
No,
order is rule one.
you are supposed to produce one decision of the Supreme Court.
Yes, lordship, the other side actually yesterday, and he was supposed to file a decision.
Yes, copy the other side is available. ইয়াতে আছিল তো অলপ আগতে আছিল এইখিনিতে আছিল তো এই আলমাৰিটোৰ ওচৰতে after some time then
Yes,
wait for him.
Right.
For motion bail application, item 1.
May I please your lordship?
Yes.
439 bail application lordship. Offense under section 8C, 22 B2C and 29 of NDPS Act lordship. Lordship,
This is first application or second application?
second application lordship.
Second.
Earlier lordship has rejected the bail lordship.
When?
The page 48 lordship. Page 48 lordship. Annexure 7.
Hmm.
The relevant portion lordship 49 lordship. Last paragraph lordship. Lordship has directed the learned trial court to expedite the trial and dispose of the case at earliest lordship. And the bail application was rejected on 11/11/2022 lordship. 11/11/2022 lordship. Lordship, as per my information lordship, till date only one witness has been examined lordship. So lordship, kindly call for the LCR lordship.
So what is the ground for filing this second application?
Lordship, he is behind the bar lordship since last 3 years, 34 days lordship.
300?
3 years lordship.
3 years.
3 years, 34 days lordship. And only one witness has been examined
How
lordship.
many witnesses cited in the search sheet?
Lordship, Lordship, 9 witnesses lordship.
9 witnesses.
9 witnesses lordship. Page number 47 lordship.
And out of 9, only one witness
Only one
examined.
lordship as per my information. Lordship, kindly call for the LCR lordship at this stage lordship.
Okay. Heard, Mr.
T. Thakuria lordship.
T. Thakuria, learned counsel for the accused, and Miss
M. Deka.
learned counsel appearing on behalf of Mr. S.C. Kayal, learned standing counsel for NCB. This petition under section 483 of the Bharatiya Nagorik Suraksha Samhita 2023 is preferred by accused Sahib Sahani, who has been languishing in jail in connection with NDPS case number 29 of 2021, arising out of NCB crime number 12 of 2021 since 18/6/2021. The learned counsel for the accused submits that this is the first or second bail application preferred by the accused, and the first one being BA number 2505 of 2022 was dismissed by this court by order dated 11/11/2022. And the ground for filing this second bail application is that the accused is languishing in jail for last 3 years, 34 days. And though 9 witnesses have been cited in the search sheet, yet only one witness could be, yet the prosecution side has been able to examine only one witness. And therefore, it is contended that the accused may be enlarged on bail. But having heard the submission of learned counsel for the petitioner as well as for the respondent NCB, it is provided that Raisi shall call for the scanned copy of the record from the learned trial court along with up-to-date status report. List the matter on
12 September.
Item number 2.
Highly obliged.
Must not be.
May I please, your lordship.
Yes,
Last occasion, your lordship asked me to produce the agreement if any, your lordship.
yes, yes.
Your lordship, 12 copy of agreement since 1987, your lordship, till filing of the suit, your lordship. Nineteen 87, 93, 96, 99, 2002, 2005, 2008, 2011, 14, 15, 16, your lordship. I have underlined the dates and periods, lordship.
Originally, there was only one room.
2 rooms, lordship. And last agreement, in the last agreement, if your lordship, there are 2 rooms, your lordship. In the plaint itself, it is pleaded, lordship, in the plaint of the respondent, lordship.
Have you enclosed the plaint along with this petition?
Yes, plaint, page 15, your lordship. Annexure 1. It is in page 16, paragraph 2, there is mentioned that over the city land, there is standing a RCC building having several rooms. The defendant took 2 rooms on lease.
Which part of the plaint it is mentioned? 2 rooms?
Lordship, page 16, kindly see, lordship.
Yes.
Paragraph 2, your lordship.
Hmm.
That over the,
Two rooms. Okay.
lordship. And in the schedule itself, it is at page 20,
Hmm.
there in the schedule. Schedule B,
Hmm.
page 20. 2 rooms of RCC building measuring Session says front room and session says rear side room. Page 20.
So why local investigation is required?
Lordship, since 1987, the petitioners paying the rent and earning her livelihood.
Hmm.
But in the year, Lordship, in the year, the plaintiff has sold out a portion of land, Your Lordship.
Hmm.
And while sold out that land, the passage, Your Lordship, shortened. And the plaintiff agreed that he will manage arrange the road corridor veranda from coming to front room to backside room, but that could not be done. But the plaintiff did not mention these parts in his pleadings.
Hmm.
That to passage is there,
Hmm.
that was not mentioned, Your Lordship. And one roof, asbestos roof, and one RCC room was there, out of
Okay.
2 rooms.
Okay. Heard, Mr.
A.R. Shom, Lordship.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner, namely Srimati Supurna Kaur, has put to challenge the correctness or otherwise of the order dated 30/7/2024 passed by the learned civil judge junior division Udalguri in Mizje case number 31 of 2023 arising out of title suit number 9 of 2017. It is to be noted here that by impugn order dated so and so the learned. Oh. It is to be noted here that by the impugn order dated 30/7/2024, the learned civil judge junior division Udalguri has dismissed the petition filed by the petitioner under Order 26 Rule 9 read with Section 151 of the Code of Civil Procedure 1908 for appointment of Commission for Local Investigation. Mr. Som, learned counsel for the petitioner, submits that the petitioner is the defendant in the title suit instituted by the respondent opposite party before the Court of Learned Civil Judge Junior Division Udalguri in Mizje case number 30 in titles being title suit number 9 of 2017. The said title suit was instituted by the respondent opposite party for ejectment of the present petitioner, her men and agent servants from the suit rooms shown in Schedule B of the said title suit. And also for recovery of area rents amounting rupees 17,500 since April 2017. The learned counsel for the petitioner submits that the petitioner is in occupation of two rooms since the year 1987.
87.
Since the year 1987, and she has been regularly paying rent to the respondent opposite party. Thereafter, when the opposite party has sold the land,
Lord, 2015 Lordship.
and thereafter in the year 2015,
Yes,
the
Your Lordship.
respondent opposite party has sold a portion of the land. For which the corridor leading to the RCC room, to the room situated behind the RCC room, was almost closed. Then the petitioner has not been provided with any alternative passage. And the said incident had happened in the year 2015, and as such, the room rent was reduced from rupees 2,600 to rupees 2,500. And instead of providing the passage to the petitioner, the respondent opposite party has instituted the title suit for ejectment of the present petitioner. The learned counsel for the petitioner further submits that the title suit number 09 of 2017 is pending at what stage it is pending?
DW complete, Your Lordship. Cross of defendant witness.
It is fixed for argument,
Argument, Your Lordship.
and the said case is pending at the stage of argument. And thereafter, the petitioner has filed a petition under Order 26, Rule 9 of the section, read Section 151 of the Code of Civil Procedure for appointment of commissioner. Appointment of commission for local investigation, but the same was rejected by the impugned order dated 38/7/2024 on the ground that the evidence of defendant's witnesses have already been closed. The learned counsel for the petitioner further submits that the impugned order suffers from illegality, and at any point of time, the court can appoint a commission under the Order 26, Rule 9, read Section 151 CPC, and therefore it is contended to allow the petition. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record and also perused the impugn order dated 30th/7/2024. It is to be noted here that while dealing with the issue of commission, Honorable Supreme Court in the case of Haryana Waqf Board versus Santi Swarup and others reported in 2008 8 SCC 671 has observed as under within inverted comma prayer number 3. The dispute that was raised by the parties before the court was whether the respondent had encroached upon any land belonging to the appellant board. Full stop. Therefore, it cannot be in dispute that the dispute was in respect of the encroachment of the said land, suit land. Number 4, admittedly, in this case, an application was filed under Order 26, Rule 9 of the Code of Civil Procedure, which was rejected by the trial court. But in view of the fact that it was a case for demarcation of the disputed land, it was appropriate for the court to direct the investigation by appointing a local commission under Order 26, Rule 9 CPC 5. The appellate court found that the trial court did not take into consideration the pleading of the parties when there was no specific denial on the part of the respondents regarding the allegation of unauthorized possession in respect of the suit land by them as per paragraph number 3 of the plaint. But the only controversy between the parties were regarding demarcation of the suit land, because land of the respondent was adjacent to the suit land and the application for demarcation filed before the trial court was wrongly rejected. Number 6, it is also not in dispute that even before the appellate court, the appellant board has filed an application for appointment of local commissioner for demarcation of the suit land. Also, in our view, this aspect of the matter was not at all gone into by the High Court while dismissing the second appeal summarily. Also, the High Court ought to have considered whether, in view of the nature of the disputes and in the facts of the present case, whether local commissioners should be appointed for the purpose of demarcation in respect of the suit land. Inverted comma close. In the incident case, though the suit was for ejectment, yet there is dispute between the petitioner and the respondent in respect of the passage in between the RCC room and the room with asbestos roof situated behind the RCC room. Given the nature of disputes between the parties, this court is of the view that appointment of a commission for local investigation would help the learned trial court in adjudicating the dispute between the petitioner and the respondent in a more effective manner. To the learned civil judge, Junior Division has dismissed the petition on the ground that the case is pending at the stage of argument and the petition has been filed at a related stage. Yet there is no bar in appointing a commission at that stage also. Having tested the ground for rejection of the petition on the touchstone of the aforesaid principle, as discussed in the case of Haryana Waqf Court. This court is within brackets of this court is of the view that the same failed to withstand the test of legal scrutiny, and accordingly the impugn order dated 30/7/2024 stands set aside. Accordingly, it is provided that the learned trial court shall appoint a commission under Order 26, Rule 9 CPC. To inquire, to know for local investigation, and thereafter proceed to hear and dispose of the suit in accordance with law in terms of this CRP is disposal at this motion is this itself.
Item top of the list, item 32.
I'm sorry, Mulad, I was not there.
You show me the judgment which you have yesterday referred to.
Para 8 and 9 months.
What is Order 9, Rule 13?
That is not applicable in our case, Mulad. Order 5, Rule 2, if your lordship sees, Mulad, that copy of the plate also has to be served.
Mm.
And Mulad, on the same analogy, Mulad, my friend has shown our High Court's order, Mulad.
Mm.
It also proceeded on the same basis. So, Mulad, it's
Lordship, I want to submit this renewable judgment, Lordship.
Lordship, para number 36. The Lordship, para number 18 also.
36.
Yes, Lordship. And the Lordship, para number 18. Relevant pair.
So here in this petition, when the copy of the documents were served upon you,
Lordship, 8/11/2023.
8
11/2023.
and when the impugned order was passed,
Lordship, 23/11/2023.
20
23/11/2023. Lordship, I was given. 15 days.
when you have received the summon,
Lordship, I received the summon on the 21/6/2023. The Lordship Court had given the direction on the 5/7/2023 to the plaintiff for furnishing the documents.
when
The 5/7/2023.
5/7/20
2023.
what happened on this date? 5/7/2023.
Lordship, 5/7/2023, I appeared and sought for time before filing the written statement. And that the Honorable Court had given a direction to the plaintiff for furnishing the documents. And that the Lordship, the plaintiff did not furnish the documents. The plaintiff furnished the documents only on 8/11/2023. So the next date was fixed 23/11/2023, when I sought for time, but the court rejected my prayer.
So you received summon on 21/6/2023
Yes, Lord.
and you have appeared before the
Court Lordship,
trial court on
5/7/2023.
5/7/2023.
Yes.
And you have prayed for
Time.
time for
Yes.
submitting written
And
statement
I sought for direction on the two.
and also for furnishing copies of the document.
Yes, Lord.
And when the order was passed,
Lordship, order was passed 23/11/2023.
23/11.
Yes, Lordship. Lordship, Annexa 13.
So Mr. Dubey, you have no objection.
No, Lord. But my friend is right on that, Lord, so far as.
Okay. Heard Mr. Devi, learned counsel for the petitioner, and also heard Mr. Dubey, learned counsel for the respondent. Correctness or otherwise of the order dated 22/11, 22 or 23.
Actually, Lordship, when the case was fixed on the 8/11, that date was given 23/11. But in the order sheet, that date is mentioned 22/11.
Order dated 22/11/2023 passed by the learned civil judge senior division Golpara in title suit number 47 of 2023 is challenged in this petition filed under Article 227 of the Constitution of India. It is to be noted here that the respondent here in this petition, Saurabh Kumar Nath, had instituted a title suit number 47 of 2023 before the learned civil judge senior division Golpara. And in the said title suit, the present petitioners have received summon on 21/6/2023. Thereafter, they have appeared before the learned Trial Court on 5/7/2023 and filed a petition for extension of time to submit the written statement and also issue direction to the respondent opposite party to furnish the copies of documents. And the said documents were furnished to the petitioners on 8/11/2023. But thereafter, by the impugn order dated 23/11/2023, the learned trial court has decided to proceed the case ex parte as in view of the decision of Honorable Supreme Court in the case of Salem Advocate Bar Association versus Union of India, reported in AIR 2005 SC 2253. And in view of the decision in Koilas Nanpako AIR 2005 SC 2441 has refused to grant extension of time as no valid reason has been shown to file the written statement beyond the stipulated period. Mr. Dewey, learned counsel for the petitioner, submits that though the petitioners have received a summon on 21/6/2023, yet the summon was not accompanied with the relevant documents for which the written statement could not be prepared and filed before the learned trial court. And as such, a petition was filed before the learned trial court on 5/7/2023. And in the said petition, the learned trial court has ordered the respondent for furnishing the documents to the petitioners. And the said documents were furnished to the petitioners on 8/11/2023. And in view of the decision of a court in advance of this court in Srinivas Vasudev MS versus Vinit Kumar Kothari, reported in 2006 3 GLT 118. The period of 90 days for filing documents, for filing written statement has to be counted from the date of furnishing the copies of the documents to the petitioners. But the learned trial court, by order dated 23/11/2023, has debarred the petitioners from filing written statement and decided to proceed ex parte. Then, as such, the impugn order suffers from illegality and therefore it is contended to set aside the same. Mr. R. Dubey, learned counsel for the respondent, also fairly submits that since the petitioners have received the copies of the documents on 8/11/2023, the period of 90 days has to be counted from that day for filing the written statement. Then from that standpoint, debarring the petitioners from filing written statement by order dated 23/11/2023 filed so withstand the legal scrutiny. And Mr. Dubey has also referred to a decision of Honorable Supreme Court in the case of MS Nahor Enterprise versus MS Hyderabad Alloy Limited and another in civil appeal number 714 of 2007, arising out of SLP, which is C number 2803 of 2005. 2005. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record, and also gone to the impugned order dated 23rd 11/2023, and the decisions referred by Mr. Terry, and also gone through the decision referred by Mr. Dubey. And I find sufficient force in the submission of Mr. Terry and Mr. Dubey. It appears that the documents were furnished to the petitioner on 8/11/2023. And in view of the decisions of the coordinate bench of this court in case number so and so, and of the Honorable Supreme Court in the case number so and so, the period of 90 days has to be counted from the date of furnishing the copies of documents, that is 8/11/2023. In that view of the matter, it cannot be said that the impugned order dated 23/11/2023 withstand the legal scrutiny, and accordingly the same is then set aside. You have not filed a written statement before that.
No, Lordship.
When you will be able to file?
Lordship, the 15 days.
When the next date is fixed?
Lordship, I don't remember the next date, Lordship.
The proceeding has been stayed, Lord, that form, Lord. Lord, my
We'll
prayer,
get it. We
Lord,
will
may
get it.
fix a date, Lord, where both
Ah.
parties would appear, and Lord, we can file his written statement.
It is provided that on or before
On or before 9th September. 15 days.
Yes, Lordship.
9 September, the petitioner shall appear before the learned trial court and furnish written statement. And thereafter, the learned trial court shall take the same on board and proceed to hear and dispose of the suit in accordance with law. In terms of above this, CRP instance disclosure.
Obliged,
Deeply
Lordship.
Order number 4, matter for admission.
May I please? My lord, on the last date, we got the copy of the transfer petition. Matter may please after 4 weeks.
Yes, you offered a petitioner.
Lordship, I am for the petitioner, Lordship. The petitioner, the respondent filed a divorce suit in the family court, and the petitioner is a resident of Sibsagar. So she had prayed for transfer of the proceeding to Sibsagar district judge, Lordship.
Lordship, we will be given chance to submit our affidavit in opposition.
You have not submitted.
We are yet to submit that.
Heard Mr. Ayerson, learned counsel for the petitioner. And Mr. V.K. Sandak, learned counsel for the respondent. Mr. Sandak submits that he may be granted 1 week.
My lord, 19 September,
Pardon?
19 September.
No. 1 week time.
Okay. In this week, this week.
Accordingly, pair of Mr. Sandak is then allowed. List the matter on Kabir. 6 September.
My lord, sister, I will be out of station. My lord, can it be on 30th August, 30th August,
When?
30th, 30. August.
Okay.
All right, man.
Oblige. I'm sorry, Lordship. Earlier interim order may be extended.
There is stay. Interim order pass earlier is there. Shall continue.
Oblige, your Lordship.
The city has been received. I can 5%. 5 to 5.
May I please, Lordship?
Mm.
Lordship, in this case, we would, there is call for, with, along with a notice to inform and Lordship,
The notice was served upon respondent number
Lordship,
2.
Where we have sent our intimation on 13/08/2024,
Mm.
but today morning I have also informed by our office that they have not received any copy of the service report. Service report is awaited, Lordship. Otherwise, Lordship, I think the present petitioner is a nurse. He is a by profession, serving as a nurse, Lordship. I think 313 will be applicable in her case. And the main accused is one Jannat Ali, Lordship, and Nekibur Islam.
Mm.
these are released.
And so far as 164 statement of the victim, she has implicated the present petitioner.
And that's all right, but the notice upon the respondent number
Can it
2
be
has
on
to
the
be served
next week, Lordship?
next week.
Yes, Lordship.
So he has to take fresh step or
No,
No, Lordship, we will take the steps. We have already sent our intimation to the concerned
Acha.
police. Lordship.
So can it be on, Tuesday, Milord, but since already in 70, 72 days, Milord.
when?
But next Tuesday, Milord.
Next Tuesday.
Lordship, Monday will be
Okay,
closed. Can it
possible.
be on 27 or 28? 28,
28 Wednesday.
Wednesday.
Okay. Heard Mr. M. Monto, learned counsel for the accused, and also heard Ms. Assis Borda, learned additional PP for the state respondent. Ms. Borda submits that she has already sent intimation to the jurisdiction officer in charge jurisdictional PS in respect of service of notice upon the respondent number 2, and the same is still awaited. And accordingly press for listing the matter on next Wednesday,
Wednesday, 28.
Wednesday.
Lordship.
28.
28. Here is accordingly allowed. List the matter on.
Much of that.
Item number 6.
Thank you.
Item number 6, Lordship. I have been informed by our office that sursit has been submitted, Lordship.
Here.
Yes, Lordship.
So what is the allegation?
Allegation under section, Lordship, 11A B, of prevention of cruelty to animal life, Lordship.
Search it submitted.
Sursit.
So he is on interim. Are you on interim?
Yes, Lordship.
When it was granted?
Lordship Vice, where it was CS
22/8.
interim was granted on 22/8/2023.
Okay. Heard Miss?
Yes, Nusrat.
Learned counsel for the applicant and Miss Assis Borda, learned additional PP for the state respondent. This application under section 438 status is preferred by applicant Mohammad Abdul Kalam
There are two petitioners, Lordship.
and Nisar Ahmed, who have been apprehending arrest in connection with Sonapur PS case number 139 of 2023 under section 379 for 1134 IPC read with section 11A B D of the Prevention of Cruelty to Animal Act 1960 read with section 13(1) of Assam Cattle Preservation Act 2021. It is to be noted here that the above noted case has been registered on the basis of an FIR lodged by UBC Corona Kakoti on 14/7/2023. The sense of allegation made in the FIR dated so and so is that the accused that one Sakib Iqbal and Ershad Khan were caught red-handed while they were carrying 30 numbers of cattle in a truck bearing registration number UP 21 CN 2107 without any valid document. The learned counsel for the applicant submits that this court by order dated 22/8/2023 was pleased to extend the privilege of interim periods bail. And pursuant to the said order, the petitioner had appeared before the IU and cooperating with the investigating agency, and therefore it is contended that the interim order dated 22/8/2023 may be made absolute in the same terms and conditions. On the other hand, Ms. S.S. Bora, learned additional PP, submits that she has not received the case diary, but as per her information, as per her instruction, the IU has completed investigation and submitted charge sheet before the learned trial court. Charge sheet being
White CS number 220/2023, dated 30/11/2023.
Since investigation has already been completed and charge sheet has been submitted here in this case, custodial interrogation of the applicant seems to be not warranted, and therefore the interim order dated so and so is hereby made absolute in the same terms and conditions in terms of above this evidence disposal.
Item number 7.
Much obliged.
FIR is at page 23, madam. This FIR is in regard to those land scam matters which was detected in offices of the Deputy Commissioner Metro.
So you are on interim.
I'm on interim. On the last
You
occasion,
appeared before the IO.
yes, madam. And basically, what has happened, my wife was an extra writer in the office of Deputy Commissioner Metro. She was arrested in 2 cases, granted bail by the court. When she was in police custody, one of the police sent this message at page 25.
Mm.
That I have been not answering to the calls from the and showing reluctancy in solacing your wife at this difficult hour. Then he thought he was apprehensive that if I go, he will be arrested. That's why he approached this honorable court for previous bail. So far the allegations is concerned, he is not any employer and no role to play in any of these transactions.
Yes, madam, city received.
The city received lordship.
So what is the stage of investigation?
Lordship, on 28/12/2023, he appeared before the IO. His statement has been recorded. And thereafter, lordship, they have given a note that lordship can go through. It's a voluminous one. I couldn't go through properly, lordship. Just I have.
No, whether the investigation is about to complete?
It's still going on, lordship.
Going on.
Yes.
Many accused have been arrested in this case. All of them have been granted a regular bail as well as previous bail.
Okay, heard Mr. B.D. Kaur, learned senior counsel assisted by Miss learned counsel for the applicants. This application under section 438 services preferred by applicant Pranab Kumar Sharma, who has been apprehending arrest in connection with cyber PS case number 12/2023 under section 120B. 419/420 IPC, rated section 66C, 66D of the IT Act 2000, added section 409, 468, and 471 IPC. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Papu Gogoi, Circle Officer, Dispute Revenue Circle. The sense of allegation made in the FIR dated so and so is that it was come to his notice that a mutation order was passed online in Authority Portal on 5/10/2023. In case number MET stroke DIS stroke 2022-23 stroke 96042 stroke OMUT against it did with serial number 6268 dated 31/12/1995, wherein no official record was found in respect of issuance of notice. And no order was found available in his office. Thereafter, he had communicated the DIO NIC Kamrup to provide login history details from 1/10/2023 till 26/10/2023. And on examination of the login history, it was found that 2 IP addresses login were made 54 times during the period of 4/10/2023 to 26/10/2023 from the IP address number 10.177.88.65 and 52 times login was made from IP address number 10.177.88.58 on 10/10/2023. And the said IP addresses and login from the said IP addresses were made unauthorizedly. Mr. B.D. Kaur, learned senior counsel for the applicant, submits that while order dated 28/12/2023, this court was placed to extend the privilege of interim periods bail to the applicant. And pursuant to the said order, the applicant had appeared before the IO and cooperating with the investigating agency. And that in fact he is no way involved with the offense alleged in the FIR, and therefore a contention is being made that the interim order dated 28/12/2023 may be made obsolete in the same terms and conditions. On the other hand, Ms. S.S. Borda, learned additional PP, has produced the case there before this court and submits that the applicant had appeared before the IO and his statement is also recorded. Further, Ms. Borda submits that the investigation of the case is still going on. But having heard the submission of learned advocates about the parties, I have carefully gone to the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Borda, learned additional PD. It appears that the applicant has been cooperating with the investigating agency. And the investigation is still going on. And in view of the fact that the applicant has been cooperating with the investigating agency, his custodial interrogation seems to be not warranted here in this case. Therefore, the interim order dated so and so is hereby made absolute
2012-2023.
in the same terms and conditions. Case diary be returned.
We are bless you.
Item 8.
Your Lordship, affidavit case study was called for, Lordship, that we have not received. Lordship, kindly give us a last chance, Lordship. Next week, any date, Lordship.
Which one? Eight.
Ms. Ashish Bora learned additional PP submits
So
that
many method. I am not-
she has not received the up-to-date case diary and press for granting her 1 week time. Here is allowed. This is the matter on
30.
30.
Obliged.
Item number 9, matters for orders.
Please, your lordship. Lordship, I have filed this, on the last two occasions, respondent did not appear, lordship. In this, their names had been shown.
Lordship, we filed evidence on affidavit, Lordship, on this next day.
When?
After 2 weeks, Lordship.
Heard, Mr.
A. Rekha, lordship.
A. Rekha, learned counsel for the applicant. And Miss
A. Datta, Lordship.
A.
A. Datta. On
A.
the behalf of
Datta.
MP Sharma.
Learned counsel appearing on behalf of Mr.
A. Datta, Lordship.
In
MP
the
Sharma.
MB,
MP Sharma, Lordship.
MB Sharma. Ms. Datta submits that the respondent will file objection in this petition, in this application, and therefore press for granting 2 weeks time.
Yes, Lord.
There is allowed recessal is the method. After 2 weeks, should we fix a date?
Yes, lordship.
On 6 September.
Interim order was there.
Till then, interim order pass earlier shall continue.
Item number 10,
Obviously.
Lordship, may I submit, Lordship, in item number 8, my learned friend has some difficulties. The matter has been fixed on 38. So he has said that he is having some difficulties. So can it be fixed on 5th, Lordship? 5th of September.
5th of September.
Obliged.
item 10.
My lord, I am appearing for the sole respondent.
You are for respondent.
Yes, yes. My lordship, it's a transfer petition, my lordship. I am the wife. Already 2 of the cases is pending before the Chief Judicial Magistrate Hailakandi. This divorce petition, which has been filed by my husband before the district judge Karimganj, my lordship. It is a 35-kilometer distance from my.
Oh, you want to get it transferred from Karimganj to
Hailakandi.
Hailakandi. So distance between Hailakandi and Karimganj is
35.
35.
Court is 30, but the distance, my lordship, in the paragraph, I have filed one additional affidavit, wherein in paragraph 4, I have stated that house of the respondent house and the court's distance is 38-kilometer district judge, and the court in Hailakandi is 29 kilometers. So for him also it is very much convenient. 29 kilometers from his house to district court Hailakandi, and from his house to district court Karimganj is 38 kilometers. So for both of us, it is very much convenient. Already 2 cases are pending in Hailakandi. One domestic violence case and one 125 proceeding, which he is appearing, and he has already entered his appearance.
My lord, we may be allowed to file our objection.
What is your objection? If we transfer the case from Karimganj to Hailakandi, then your distance will be reduced from your native place to the court at Karimganj.
Yes.
My lord, even though as per my senior's request, I am praying for filing objection.
Who is your senior?
Mr. Shishir Datta, my lord.
So 1 week time?
Fine.
Heard, Mr.
SB Loskar.
S.
SB Loskar.
SB Loskar, learned counsel for the petitioner, and Madam
S. Musahari, my lord.
S. Musahari, learned counsel, appearing on behalf of Mr. S. Datta.
My lord.
No, your name is also there.
Yes, my lord.
S. Musahari, learned counsel for the respondent. Ms. Musahari submits that she may be granted 1 week time to file objection in this petition. Here is accordingly allowed. Recessal is the matter after 1 week.
of license.
The date will be fixed.
Date
On 5th September.
5th of September.
Highly.
Yes.
Item number 11, matter for hearing, Farhad matter.
Please, the lordship, my lord. On the part of respondent, my lord, day before yesterday, instruction is received that the sole appellant expired in the month of January, my lord. If the sole appellant expired, my lord, the appeal is already awaited, my lord. It's not.
Whether he left behind some legal representative or not. Here,
Legal is there, legal is there as per instruction.
They can continue. Yes.
From my friend, learned friend, my lord, today morning I have come to know, my lord.
Acha.
So I need to take instruction, my lord. And
Okay.
4 weeks time may be granted, my lord.
4
If
weeks.
he has died in the month of January, then suit is awaited, my lord. So I need to bring substitution, my lord.
Yes.
Legal heirs may be substituted, my lord.
Yes.
So I need 4 weeks time, my lord. In that case.
Heard Mr. I.S. Loskar, learned counsel for the appellant, and Mr. M.J. Kadir, learned counsel for the respondent. Mr. Kadir submits that as per his information, the sole respondent suffered demise in the month of January of 2024.
Yes.
2024. Sole respondent. No, sole appellant. Mr. Loskar, learned counsel for the appellant, submits that he has to obtain instruction in this regard and press for granting him 4 weeks time. Pair is accordingly allowed. Recessal is the matter after 4 weeks.
My lord, a little less time may be granted, my lord.
Pardon?
16 matter, my lord. At least a little less time is granted. 3 weeks, my lord.
Now, first he has to ascertain whether he is alive or not.
My lord,
If he suffered demise only, then he will take a step for substituting the legal heirs.
so my lord, for taking instruction, my lord, long time is not required, my lord. My friend. For
No, that's all right, but he has to take a step also.
Yes.
My lord, 4 weeks minimum time because I need to send letter to him or his so that I may.
You have no contact number.
So, my lord, at least 4 weeks time maybe.
Okay.
Item 12,
Alright.
Farhad matter.
On last occasion, Lordship, I have read the judgment of the title appeal, Lordship.
Hmm.
We are the defendant in the title suit, Lordship. And respondent herein with the plaintiffs, Lordship. Title suit was dismissed, Lordship, by the Learned Trial Court. In the title suit, we have filed the counterclaim that was also dismissed by the trial court. Against the dismissal of the title suit, Lordship, the plaintiff filed a title appeal, which was allowed, Lordship. The plaintiff claimed their title through a pattanama executed by the father of the pro forma defendant, Lordship. In the title appeal, Lordship, the appellate court hold that the pattanama executed by the father of the pro forma defendant was a valid document, and the khazana receipt, which was also executed by the father of the pro forma defendant, that was also held to be valid under the presumption of section 91 of the Evidence Act. It was a 30 years old document, so that was recovered from the custody of the plaintiffs, and plaintiffs should be the custodian of the documents, and accordingly those documents were held to be valid documents, and accordingly the title the trial judgment of the trial court was reversed, Lordship, and accordingly the title appeal was allowed, Lordship. In the memo of appeal, Lordship,
three substantial questions were formulated, Lordship. Page number 4 of the memo of appeal, Lordship. Whether the exhibit 1 list Potta number of the year 19.
No. You come to the order dated
Yes,
4/6,
Lordship.
2018.
Yeah, the question of law formulated in that memo of appeal, Lordship, that was little bit changed by order dated June of 2018, Lordship. In the memo of appeal, the question of law formulated was slightly different, Lordship. And
No, maybe, but we have to go by the order dated 4/6, 2018.
yes, Lordship. Lordship, that is the only point here to be hearing to be decided whether the judgment of the larger trial appellate court, Lordship, that since the Potta number was recovered from the custody of the plaintiff, who should be the custodian of the documents, and since it was executed more than 30 years before, whether that presumption is a valid presumption or not. If that is decided in favor of the plaintiff's, Lordship, then my submission is that since it was not executed by the father of the pro forma defendant, so this is not a valid, and with PW's Lordship, they have submitted that they did not see who has executed these documents, Lordship.
So this exhibit 2.
Exhibit 2, Lordship, 1 and 2, the both, Lordship, they have stated that they did not see that the father of the pro forma defendant has executed this Potta number and Khazna receipt or not, Lordship. So in my submission, Lordship, the decision of the learned trial appellate court, that since it was a 30 years document, so according to section 91 of the evidence, that is a valid document. That is a wrong decision taken by the appellate court, Lordship. And on that ground, the title appeal should not have been allowed by the learned trial appellate court, Lordship. If your Lordship come to the judgment of the title suit, Lordship, at page number 21, Lordship. Page number 22, Lordship. Penultimate paragraph, Lordship. Put to cross examination.
Page number 20.
22, Lordship. The judgment of the title suit, Lordship. Issue number
22 is the decree. Which judgment? Judgment of the appellate court or the trial court?
trial court, Lordship. Page number 18, it starts from page number 18, Lordship.
Page number
18.
18.
Yes, Lordship.
Yes, order. Paragraph number?
Paragraph number, Lordship. Issue number 1, 6 and 7, Lordship, as you Lordship got at page number 22, Lordship. Issue number 1, 6 and 7. at page number 22. Please.
Page number 20,
Two lots.
issue number?
Issue number 1, 6 and 7.
Yes.
Lordship, first. Second paragraph, put to cross examination, Lordship. PW one stated,
Yes.
put to cross examination, PW one stated that exhibit 2 land revenue receipts were written by Goni Sarkar. PW one stated that the suit land originally belonged to Farid Sarkar, but at present he himself owns the land. PW one stated that he has filed a suit for cancellation of mutation order and that he has not preferred any appeal against the cancellation of mutation order. PW one admitted that Nasimuddin and Kasimuddin was tenant over the suit land, but at present they do not possess the same. PW2 after Hussain and PW3 Bosiruddin SK deposed that Abdul Ghani Sarkar settled Schedule B land by a patta number to Abdul Sahid in 1362 BS, and the latter transferred certain lands to Noor Abedin and Majibur Rahman, who all are possessing the said lands for more than 50 years. In his cross-examination, PW2 admitted that he does not know when Abdul Ghani Sarkar executed patta number. PW2 further stated that plaintiff's number 1 house is situated at half furlong distance from the suit land. PW3 stated in cross-examination that he cannot say when the patta number was executed, but the suit land is recorded in Abdul Sahid's name. So the PW2 and 3, they stated that they did not know when and who has executed the patta number. PW4 Joydev Mandal, official witness, proved the exhibit 13 case record of miscase number so and so. PW4 deposed that the names of Pattada Farid Sarkar and Rayat Noor Abedin was struck off and were replaced by Abdul Hamid Ahmed, Hamidul Islam, Habibul Islam and Hasibul Islam, and the plaintiffs are in possession. On the contrary, DW1 Muhammad Hamidul Islam deposed that the plaintiffs were neither allotted with the suit land nor were tenant at any point of time, nor paid any rent to Farid Sarkar. DW1 deposed that the land records were illegally prepared and was rightly cancelled. DW1 went to depose that Abdul Ghani Sarkar executed a power of attorney in favor of one Sayyidul Rahman, whose sons, dependent number 1 and 4, names were recorded in the records of right. DW1 identified the power of attorney as Exhibit A, Zamabandi as Exhibit B, landholding certificate as Exhibit C, and Katsa Patta as Exhibit D. Put to cross-examination, DW1 admitted that he can neither say the measurement of the suit land nor can say he has filed a counterclaim, for DW1 stated that the miscase number so and so was filed on the basis of Exhibit A, power of attorney, which was given to him by his mother. DW1 admitted that Exhibit A, power of attorney, does not contain the particulars of land as it dark number, patta number, khaitan number. DW1 admitted that during the lifetime of his father, there was no dispute with the plaintiffs, and till date, the plaintiffs possess the suit land since 1988, having dwelling houses and used for business purpose. Having taken stock of testimonies of the witnesses and the arguments founded thereon, it is thus apparent that the defendants are claiming the suit land on the basis of Exhibit A, power of attorney. I have gone through the said Exhibit A, power of attorney. Exhibit A is not a title deed, but a general power of attorney, and normally a person by executing a power of attorney cannot confer any title in respect of immovable property to any person. On the other hand, Exhibit 9, certified copy of the order dated so and so, passed by Assistant Settlement Officer Mangasar in miscase number so and so reveals that the defendant's name as riots in respect of the suit land was based on Chitha record and oral evidence. It is the case of the plaintiffs that the riotic khaitan was issued in their favor on the basis of their possession, and subsequently the riotic khaitan was cancelled by SO Thupri in miscase number so and so. Normally, the riotic khaitan khatian is issued under the provision of section 50 read with section 35 of the Act in favor of a person who has mutated his name in records of rights as riots. PW1 has only brought in 2 land receipts marked as Exhibit 2 and 3, which land receipts do not contain any signature or thumb impression of the landlord. PW1, though brought in the riotic khatian Exhibit 456 on record, but the plaintiffs have not shown or averred that as a riot they possess the title, they possess the suit land under khatiandars and had paid rent to the khatiandars regularly. In this respect, neither the plaintiffs nor any of the PWs have mentioned anything about the fact that the plaintiffs, or for that matter PW1, paid rent regularly to khatiandars under whom the plaintiffs claim themselves to be riots, which only weakens the plaintiffs' stand that they are riots under khatiandars. Thus, it is implied that the plaintiffs are not riots under the khatiandars for which they have been issued riotic khaitan, Exhibit 4, 5, and 6. It is in the evidence of PW1 that he has not preferred any appeal against the cancellation of mutation order, and that PW2 does not know when Abdul Ghani Sarkar executed the patta number. PW2 further stated that the plaintiff number 1's house is situated half furlong distance from the suit land. PW3 stated in cross-examination that he cannot say when the patta number was executed, but the suit land is recorded in Abdul Shahid's name. PW4 official witness deposed the names of the pattadar Farid Sarkar and riots Noor Abedin were struck off and were replaced by Abdul Hamid Ahmed. These are the defendants. The plaintiff's evidence reveals that the suit land is recorded in defendant's name but possessed by plaintiffs. However, it is settled that mutation is the prima facie proof of possession. In that view of the matter, the possession of the suit land by defendant only entitles them to have possessory right over the suit land. Certainly, the plaintiffs have not been able to prove the pattanama issued by PW1 by Abdul Ghani Sarkar, as the PWs that is PW2 and 3 have unanimously admitted that do not know when the Exhibit A pattanama was executed. Plaintiff's possession of the suit land is all the more doubtful as PW2 has categorically stated in cross-examination that the plaintiff number 1's house is situated at half furlong distance from the suit land. Consequently, it can be inferred that the plaintiffs have failed to probabilize their right title interest and possession over the Schedule B land, and plaintiffs cannot derive any transferable right over the suit land. On the other hand, the counterclaimants have categorically averred in the written statement that the plaintiffs are mere permissive possessor over the suit land. However, DW1 has remained silent in this respect, as DW1 has only deposed as regards to plaintiff occupying the suit land as illegal occupants, and hence for want of evidence as regards the plaintiff's status as permissive possessor, it cannot be held that the plaintiffs are permissive possessor over the Schedule B land as alleged. As regards the prayer of defendant's claim of khas possession of Schedule B land, it is already been held herein above that the possession of the suit land by the defendant only entitles them to have possessory right over the suit land, and without establishing their right, title, and interest over the Schedule B land, the defendant cannot claim a decree for khas possession as such. For the discussion, and all three issues are decided in negative. thus to the extent above.
Okay. After 5 minutes,
Yes.
come back. Yes.
So they have claimed their title, the plaintiffs have claimed their title on two documents. One is the patta number executed by the Abdul Ghani Sarkar, and the other two are the receipts. And both these two documents were not seen by any of the PWs to be executed by the actual patta dalals. So, and the appellate court held that this document is valid by invoking the provision of section 91 of the evidence on presumption. So according to me, that should not have been held as valid documents by the appellate court, and the appellate court should have dismissed the title appeal referred to the plaintiff's. That is my submission.
Yes.
The determination of the appellate court on issue number 167, Lordship, at page number 39. That may let me read that portion, Lordship.
Page number
39, Lordship. This is the appellate court judgment. Points for determination.
Yes.
Points for
Rightly decided.
Yes, Lordship. The Landed Trial Court had rightly decided issue number 167, wherein it is held that the plaintiffs has failed to prove their right title and interest over the suit land, and also held that the defendants are not entitled to recover the khas possession of the suit land. The Learned Counsel for the plaintiff's appellant, see so and so. Not so kindly come to paragraph.
Yes. Yes.
I have perused the impugned judgment and case records. The perusal of the impugned judgment reveals that the Learned Trial Court has ignored the patta number by which the plaintiff number 1 allegedly came into possession of the suit land as riot under Abdul Ghani Sarkar way back in the year 1956-57. The Learned Trial Court had, in the impugned judgment, observed that the plaintiff's witness could not state as to when the aforesaid Exhibit 1 patta number was executed, and as such, the Learned Trial Court did not consider the said patta number. The Learned Trial Court had also observed in the impugned judgment that the plaintiffs have not averred that they had paid rent to the land bill. As such, the plea of leniency of the plaintiffs was not believed by the Learned Trial Court. Now let me discuss the entire materials. The plaintiff number 1, Sri Abdul Shahid, had deposed that the Abdul Ghani Sarkar, who was the owner of the suit land, had settled the suit land in his favor by execution of the patta number marked as Exhibit 1. I have perused the Exhibit 1, and it appears that the executed Sri Abdul Ghani Sarkar has settled the suit land in favor of plaintiff number 1, Sri Abdul Shahid, as tenant upon payment of rent, and had even fixed the yearly rent of the said land. The PW1 Sri Abdul Shahid had identified the aforesaid patta number and had stated in his cross-examination that the patta number was written by one Somesh Sarkar and was executed by Abdul Ghani Sarkar. It is an admitted fact that Abdul Ghani Sarkar is presently dead. The perusal of Exhibit 1 reveals that the aforesaid patta number was executed on 27/13/62 in Bengali year. The Bengali year of 1362 would correspond to the English year 1956-57. As such, it is seen that the Exhibit 1 is a document which is more than 30 years old. Hence, the legal presumption under Section 90 of the Evidence Act 1872 can very well be drawn and it can be presumed that the aforesaid exhibit was properly and duly executed by the executor, Sri Abdul Ghani Sarkar. The fact that the exhibit 1 is a document which is more than 30 years old and is produced by the plaintiff number 1, who is the person in whose favor the suit land was settled by the exhibit 1, and it shows that the production of the above document is done from proper custody. In addition to above, it is admitted fact that Abdul Ghani Sarkar, the executor of the above document, is dead. As such, it is held that the plaintiff have properly proved the due execution of exhibit 1. The PW1 Sri Abdul Shahid had further produced the rent payment receipts marked as exhibit 2 and exhibit 3 to show that he had paid the rent of the suit land to Abdul Ghani Sarkar. The perusal of exhibit 2 reveals that the same pertains to the Bengali year 1362, that is the English year of 1956-57. The PW1 was cross-examined in respect of the aforesaid document, and this cross-examiners he had specifically stated that the exhibit 2 rent payment receipt was written by Abdul Ghani Sarkar. There is nothing on record to doubt or disbelieve the above statement of PW1. In addition to above, the exhibit 2 is also a document which is more than 30 years old and is produced from proper custody of PW1, Sri Abdul Shahid. The custody of the above document is held to be proper because the above rent was paid by Sri Abdul Shahid. As such, it is natural that the receipt would be with him. Considering the facts that the exhibit 2 is a document which is 30 years old and is produced from proper custody, it is presumed that the same is executed by Abdul Ghani Sarkar after receipt of the rent for the suit land. The learned counsel for the respondents had contended that the exhibit 2 does not contain the signature of Abdul Ghani Sarkar. As such, the same cannot be relied upon. The above contention of the respondents is not sustainable because the PW1 had specifically stated that exhibit 2 was written by Abdul Ghani Sarkar, which means that he had executed the same after receipt of the rent, and merely because the signature of Abdul Ghani Sarkar is not present, same would not make the exhibit 2 inadmissible. It is seen from the above that Abdul Ghani Sarkar had settled the above said suit land in favor of the plaintiff number 1 upon execution of the exhibit 1, and further he had received the rent for the aforesaid suit land by execution of exhibit 2. As such, the finding of the learned trial court to the effect that the plaintiff have failed to aver and prove that they are the tenants under Abdul Ghani Sarkar is held to be erroneous and not based upon the materials on ground. Two documents only they rely. One is the partner number and the other other data rent receipts. There were
Exhibit 1 and Exhibit 2.
Yes. So for this, the appellate court held as valid documents under presumption. Otherwise, the plaintiffs has nothing to prove their title over the suit land. Since it was a more than 30 years document, it was held. There was in the receipts, land revenue receipts, and in the partner number, there was no signature of the Abdul Ghani Sarkar. Plaintiff number 1, he has stated in his deposition that it was written by Abdul Ghani Sarkar. There was no signature. And he has produced 2 witnesses in his favor, PW 2 and 3, and they have stated clearly that they have not seen that Abdul Ghani Sarkar or whoever else has executed those documents. So only on presumption, these documents are held to be valid, and accordingly, the title appeal was allowed in favor of the plaintiffs.
So your part is over.
Yes.
Yes,
May it please your lordship. Lordship, the respondents are the plaintiffs, lordship. Their prayer in the plaint, page 8, lordship. Kindly see that the prayers mentioned in the plaint,
page number
8, lordship, of the appeal memo.
yes,
For a decree of declaration that the plaintiffs have right title interest with confirmation of possession of the lands described in Schedule B as per Rayati Khatiyan. For a decree of declaration that the defendant number 6 has no legal authority to cancel the Rayati Khatiyan already issued in the names of the plaintiffs, and the defendant number 7 has no legal right to correct the land records of the suit land in the name of the defendant number 1 to 4 on the basis of illegal order of defendant number 6. For a decree of permanent injunction restraining the defendant number 1 to 4, their servants, agents, etc. from interfering and dispossessing the plaintiffs from the suit land. So from the prayer portion, it is reflected that they are claiming right title on the basis of Exhibit 1, and confirmation was also there in their favor, but their names were, lordship, wrongly, lordships, corrected by the defendant number 6. So the prayer was itself made in the plaint to correct the revenue record by cancelling the wrong deletion of the name of the plaintiff's, lordship. And after that, lordship, the defendants appeared, they filed their counterclaim, lordship.
at page number,
Page number, lordship, the relevant portion, page 15 and 16, lordship. No, lordship, this is a reply to the counterclaim. Their counterclaim is page 12, lordship. Page 12, written statement. That is page 10, lordship. Annexure, they have not made it annexure, but it is page 10 to 11, lordship. Their prayer is mentioned in para 8, lordship. That the defendant claimants therefore claim and pray for a decree declaring that plaintiffs were mere permissive possessor over the land of Schedule B and are devoid of any title as tenant and are liable to be evicted from the suit land of Schedule B. A decree for recovery of possession by evicting the plaintiffs, their legal heirs and agents by demolishing all structures made over the suit land of Schedule B. A decree of perpetual injunction restraining the plaintiffs from making any new and pakka construction over the suit land. A decree for entire cost of the defendant's suit and other relief as the defendants are entitled in law, equity and good conscience. So that is the prayer of the defendants in their counterclaim, lordship. And my learned friend has just read, lordship, the trial court judgment. Page 24 and 25, lordship.
yes,
Page 24, second paragraph says the plaintiff's evidence reveals that the suit land is recorded in defendant's names, but possessed by plaintiffs. So our prayer was, lordship, for cancellation of the name of the defendants. Their names were recorded wrongly, so we filed the suit, lordship. And from the counterclaim prayer, lordship, it is reflected that we are possessing the suit lands, lordship. Their prayer was for recovery of khas possession, lordship. So, lordship, however, it is settled that mutation is the prima facie proof of possession. In that view of the matter, the possession of the suit land by the defendants only entitles them to have possessory right over the suit land. These are wrong findings by the trial court, lordship. Possession already in our favor, that is already admitted by defendants in their counterclaim. And again, there's the trial court saying that possession, in that view of the matter, the possession of the suit land by the defendants. Contrarily, the plaintiffs have not been able to prove the pattanama issued by PW1 by Abdul Ghani Sarkar. So first appellate court already held that by that time Abdul Ghani Sarkar is a dead person, Lordship. As he is a dead person, Lordship, so presumption was taken by the first appellate court, Lordship. As both the PWs, that is PW2 and PW3 have unanimously admitted that they do not know when the Exhibit A Pattanama was executed. They cannot say when the Pattanama was executed, but they have admitted in the cross and in the evidence that on the basis of Pattanama, plaintiffs were possessing the suit land, Lordship. As it is executed in the year 1956-57, Lordship, the PWs are not aware when it was executed. Only that part, Lordship. But they are admitting in the evidences that on the basis of Pattanama, we are possessing, Lordship. So our possession, not illegal possession, Lordship. Plaintiff's possession over the suit land is all the more doubtful as PW2 has categorically stated in cross-examination that the plaintiff number 1's house is situated at 1.5 furlong distance from the suit land. We have already stated in our plaint that we have already handed over 12 Chatak to Mujibur, 12 Chatak to Noor Hussain, Lordship. Already lands were handed over to other plaintiffs, Lordship. So on that basis, it cannot be held that plaintiff has no possession, Lordship. Consequently, it can be inferred that the plaintiffs have failed to probabilize their right title, interest, and possession over the scheduled land, and plaintiffs cannot derive any transferable right over the suit land. On the other hand, the counterclaimants have categorically averred in their written statement that the plaintiffs are mere permissive possessor over the suit land. However, DW1 has remained silent in this respect, as DW1 has only deposed as regards to plaintiffs occupying the suit land as illegal occupants, and hence for want of evidence as regards to plaintiff's status as permissive possessor, it cannot be held that the plaintiffs are permissive possessor over the Schedule B land as alleged. As regards to the prayer of defendant's claim of khas possession of Schedule B land, it has already been held herein above that the possession of the suit land by the defendants only entitles them. So again, contradictory statements are by the trial court, Lordship. Once it is saying that possession by the plaintiff and again saying possession by the defendants, Lordship. Only entitles them to have possessory right over the said land without establishing their right title interest over the Schedule B land. The defendants cannot claim a decree for khas possession as such. So their counterclaim was rejected, Lordship. That was dismissed. Suit was also dismissed, counterclaim was also dismissed. Then we prefer title appeal, Lordship, against the dismissal of the suit. As there is a counterclaim, Lordship, it reflects that there are two suits, one by the plaintiff and one by the defendant, Lordship. Though it is a common judgment, Lordship, suit was dismissed, we immediately filed title appeal. Counterclaim was dismissed, they did not prefer any first appeal, Lordship. And it is reflected in the judgment also. Decision portion, Lordship, first appellate court, page 49.
Page number?
49, Lordship. After drawing presumption over Exhibit 1 and 2, the decision rendered by the first appellate court, paragraph 30, Lordship.
Yes.
The decision of the learned trial court in the issue number 1, 6, and 7 is hereby set aside, and it is held that the plaintiffs have right title and interest and possession over the Schedule B land as permanent tenants, riots, and that they are not permissive occupiers under the defendants, and hence they are not liable to be evicted from the Schedule B land. The perusal of the impugned judgment reveals that the learned trial court had dismissed the counterclaim filed by the defendant number 1 to 4 and further decided the issue number 3, 4, and 5 against them. But the defendant number 1 to 4 had not filed any separate appeal or cross-objection appeal. As such, the above issues are not required to be decided afresh because the same are not challenged by any of the parties.
The appellants have not challenged the decision of the learned trial court in the issue number 9 and 10, and I further do not find any infirmity in the decisions of the above issues. That was in regard to the plaintiff's lordship. In view of the above discussions and more particularly the decisions reached in the issue numbers 1, 6, and 7, it is held that the learned trial court had erred in deciding the issue number 2 and 8. As such, the decision of the learned trial court in the issue number 2 and 8 are set aside. It is held that the plaintiffs have the right, title, interest, and possession over the Schedule B land. It is further held that the cancellation of the names of the plaintiffs by order dated so and so is illegal and liable to be set aside and revenue records be corrected. Now, my learned friend is arguing that whether on the basis of presumption that 30 years document can be presumed to be proved lordship as per section 90 lordship. Section 90 of Evidence Act says presumption as to documents 30 years old.
Yes.
Where any document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. So when Ganesh Sarkar was that person at the time of exhibiting the document, court has rightly taken presumption under section 90 lordship. It is a 30 years old document and lordship it was exhibited from the proper custody of plaintiff lordship. He is the custodian of that document lordship. In this case, lordship, I am relying on the judgment of 2007 2 GLT, page 399, paragraph 21-22, lordship.
Sorry, I brought copy of already. Yes.
Lordship, I have only one copy, so I have handed over on relying on Privy Council's decision, lordship.
Which one this
Para 21, lordship. Honorable Justice Amitabh Roy, lordship. I have flag mark, yellow flag mark. Thousand 7 2 GLT 399. Two 399. Condition, huh? 399. Condition. 399. Bipin Chandra Kolika.
Okay.
So, lordship, already possession, in fact, lordship, by the trial court also held that though land records were corrected in the name of the defendants, possession was already in favor of the plaintiffs, lordship. And the defendants also admitted in their counterclaim that possession is with us, lordship. So our prayer was only to correct the revenue records, lordship. So only the plaintiffs are required to prove their right title interest, lordship. That was proved by the exhibit 1, 2, 3, lordship. There are some other exhibited documents are also, lordship, that is exhibit 4, 5, 6. These are also Rayati Khatiyans, lordship. These Rayati Khatiyans also shows that the plaintiffs are in possession of the suit land since 24 to 25 years, lordship. So my humble submission, lordship, merely on the basis that a presumption was taken by the first appellate court, lordship. My exhibited documents may not be, it is not correct that under section 90 presumption cannot be taken, lordship. It is admitted that these are the 30 years old document, lordship.
Yes,
And PW 1, 2, 3, lordship. If your lordship allows, I can read out all the statements by the PW, lordship. They have admitted that the suit lands were, lordship, given to the plaintiff on the basis of that Pattanama, lordship.
at page number
No, lordship, these are in the lower court
or
records.
record. Yes. Copies are with you?
Yes, lordship.
Okay. Oh.
So PW 2 and 3 in cross stated that, lordship, they cannot say when Pattanama was executed. But lordship, it is reflected that they admitted since 30 to 40 years, they are in possession of the suit land, lordship. PW source. These are exhibits, Lordship. These are exhibit. Last one. Yellow flag is the PW2, Lordship.
Yes,
After the evidence, the cross part is there, Lordship.
cross part
Lordship. Second paragraph, it says second. one.
is handwritten.
Put- The
Yes.
handwriting is very horrible. Lordship. I do not have any knowledge of Bengali calendar, Lordship. I cannot. May I read the entire
These are vernacular.
English, Lordship. I know Farid Sheikh, but I do not know his legal heirs. Who is the receiver?
This is in vernacular. You were reading cross part.
Yes, Lordship.
Yeah, cross part is in.
PW1, your Lordship is looking the PW1.
Yeah.
PW2, your Lordship can read, that is English, Lordship. Yellow flag, below a yellow flag, Lordship.
Yes.
I am illiterate. I know Farid Sheikh, but I do not know his legal heirs. I do not even know the daughter of Abdul Ghani Sarkar. I do not know when Ghani Sarkar died, but it will be about 20 to 25 years ago. So it is admitted that Ghani Sarkar is dead at the time of exhibiting the documents, Lordship. When Abdul Ghani Sarkar executed Pattanama, I do not know. I do not have any knowledge of Bengali calendar. I cannot say how plaintiff number 2 and 3 came in possession. They were in possession since 30 to 40 years before, but I cannot say accurate the year. So it is proved that since 30 to 40 years, the plaintiffs are in possession, Lordship. Thereafter, the tag number and all these, Lordship. So PW2 also says that they are in possession of the suit land since 30 to 40 years, and PW3 also says it is also in English, Lordship. I cannot read and write. When I purchased my land, I do not know. I cannot say when the Pattanama has been executed and in whose presence the same has been executed. I do not know. Chanmamu Ghani Sarkar died long ago, about 40 to 45 years ago. Ghani Sarkar expired in Bangladesh, village Naukapara. Joimuddin Sheikh is my village uncle. I do not know Domushuddin. Later on, I know Domuruddin, but he has expired. Mojibur Rahman died leaving behind 4 daughters, 1 son. I know late Shahidur Rahman. I cannot say about legal heirs of Shahidur Rahman. At present, suit land is recorded in the name of Sahed as Pattadar. Abdul Sahed has received the document as Pattadar about 40 to 45 years ago. It is not, Abdul Sahed is plaintiff number 1, Lordship. It is not a fact that Abdul Sahed did not receive Patta about 40 to 45 years ago. I do not know whether Chan Mahmud died living Ganesh Sarkar. I do not know the sons of Farid Sarkar. I do not know about legal heirs of Abdul Ghani Sarkar. It is not a fact that I am deposing falsely. So he also admitted that Abdul Shahid, it is not a fact that Abdul Shahid did not receive patta about 40 to 45 years ago. So
Where?
PW3 cross part, Lordship.
Yes.
Last portion, Lordship.
Uh,
Page number was also not given. At present, suit land is recorded, Lordship. After that para, at present, suit land is recorded in the name of Shahid as Pattadar. Second page of the cross-examination.
Yes. Yes, at present.
Suit land is recorded in the name of Shahid as Pattadar. PW1 Shahid, plaintiff number 1 Shahid, Lordship. Abdul Shahid has received the document as Pattadar about 40 to 45 years ago. So that Pattannama, Lordship, Abdul Shahid received 40 to 45 years ago. It is admitted by PW3, Lordship. Then again, he said it is not a fact that Abdul Shahid did not receive patta about 40 to 45 years ago. I do not know whether Jan Mahmud died living Ganesh Sarkar. I do not know the sons of Farid Sarkar. I do not know about legal heirs of Abdul Ghani Sarkar. It is not a fact that I am deposing falsely. So these are the statements by PW3. So Rashid, the PW3 may be stated that I do not know when Pattanama was executed, but they admitted that plaintiff is the Pattadar since 40 to 45 years and he is possessing the lands, Lordship. So the cancellation of the name of the plaintiff from the revenue records by defendant number 6 is illegal, Lordship. So the first appellate court rightly granted all the reliefs to the plaintiffs as he is possessing since 40 to 45 years, Lordship, on the basis of Exhibit 1. And first appellate court rightly taken presumption for Exhibit 1 to Lordship on the basis of 30 years old document. So my humble submission, there is no illegality in the findings of the first appellate court, Lordship. And Lordship, they have not preferred any appeal against counterclaim. Counterclaim already gone, Lordship. The trial court judgment is on 27/1/2011, Lordship. 27/1/2011. Thereafter, Lordship, their counterclaim, no appeal was filed by them, Lordship. So it attained finality in the year 2011. Suit is of the year 2005. At that relevant point of time, we are possessing since 40 to 45 years, and now, Lordship, it almost 65 years, Lordship. So my humble submission, these are not a substantial question of law in affirmative in favor of the appellant's, Lordship. So there is no illegality in the findings of the learned first appellate court, Lordship, in deciding the first appeal.
Yes, any reply? No. Heard Mr. Eddie Soduri, learned counsel for the appellant, and Ms. R. Soduri, learned counsel for the respondent. Argument concluded, order is judgment reserved.
After 6, 7, 8. Government is also a party, Lordship. 6, 7, 8.
Government.
Yes.
Okay. Also heard Mr. Gogoi, learned counsel for the respondent number 678.
Of that.
With regard to item number 15, my lord, in this matter, my lord, I was instructed to produce a copy of the goods tariff number 45 on behalf of the.
Item
railways.
number 15.
15, my lord. That person who is having the custody of that book, he is on leave, so I'm not in a position to place that book. So can another date be fixed in the matter?
Who is for the other side?
Lordship, I'm for the appellant.
Acha,
Lordship, kindly this matter may be listed on 19th of September, Lordship.
19.
19.
Yes.
Okay. As agreed by learned advocates of both sides, recessal list the matter on 19th of September.
Much.
Okay.
Item number 26, upgraded.
Hmm.
Let me start by saying that, my lord, I am a judgment debtor owing an amount of not less than 60 lakhs, my lord, in terms of rent for the premises that we utilize for the purpose of our office, and in respect of which a decree was granted by the learned court below against us. We filed a first appeal, and that the interim order that was granted earlier was conditional, and that we failed to, my lord, meet the conditions, and it went down to the execution court. And against an order passed in the proceeding, my lord, we have come by filing IA, my lord. That order, your lordship will file it, find that page 46 of the appeal of the IA, my lord. IA number 744 in RFA 27 of 202. Page
Page number 46.
My lord, the last page.
Yes.
My lord, may I just read it?
Mm.
Parties are represented by petition number so and so, learned counsel for the judgment debtors have prayed for permission to withdraw Okalatama on the ground that no communication could be made with the judgment debtors on account of which necessary instruction could not be obtained. My lord, this is by the then counsel who was representing the appellant. Hard petition shall be considered filing of retirement notice, postal receipt and track consignment report by petition number so and so, dated so and so, learned counsel for the decree holder submitted GST invoices for the period September to 23. Learned counsel for decree holder has also submitted police cost, treasury challan, reissue writ of possession and attachment of movable property against the judgment debtors, fix so and so for report of submission. My lord, we came against this by filing this IA, in which this honorable court, after hearing the parties, my lord, intervened by granting a stay, my lord. And that stay has been extended till date, my lord. The background is this, my lord. The company having failed. No. The company having failed, it has utilized the services of a reconstruction bank, my lord. What is called a reconstruction bank? This is called, my lord. This is in our the affidavit, my lord, that we have filed yesterday, my lord. Edelweiss Alternative Asset Advisor Limited, Mumbai. That para 3, man.
Okay.
Now, my lord, they are going to sponsor us to the tune of 245 crore, my lord. And my lord, to that end, my lord, para 3, man. That may kind of.
Yes.
My lord, here we have mentioned the investor, the reconstruction bank, my lord, is named Edelweiss Alternative Asset Advisors Limited, Mumbai, which is going to, my lord, invest an amount of 245 crore, my lord. And to that extent, my lord, that what is called a binding agreement has been also executed on 14th of August 2024, my lord. Now, for this purpose also they require collaterals, and we have got 4 parcels of land. And now, my lord, for creation of mortgage also, my lord, we need some time. Your lordship is aware that, my lord, the new system of online application and uploading of supporting documents and all that, my lord. This is from the district commissioner's permission is required, my lord. After which that mortgage can be created in the registry office, man. Now that process is going on, and we have already stated here, my lord, in para 4, that all documentation regarding due diligence, audit of accounts and plans are completed. Our plans have been inspected by them, the reconstruction agents, except the creation of mortgage. The documentation for creation of mortgage, that is NOC, is issued by the Office of District Commissioner, Kamrun Metro. Since the plant is at Sonapur, it's a cement manufacturing plant. Amber Village, JSB Cement LLP, which is under Kamrup Metro District Administration. We have 4 parcels, plots of land. Process is online to apply for NOC for creation of mortgage, and documents required are NEC Form 50, which we have already obtained. Affidavit from mortgage or mortgagee. Updated Jamabandi, trace map, Chitha map, caste certificate for tribal belts. The land, these 4 plots are in tribal belt minor. One of our directors is a tribal gentleman, along with registered sale deeds to be uploaded online for NOC for creation of mortgage, to be verified by the Circle Office Sonapur and forwarded to the Office of District Commissioner for issuance of NOC. My lord, all this, my lord, these requirements, my lord, they again require time, my lord, for that. So we need further time, my lord. We have calculated on a conservative scale, my lord, require another 45 days for NOC and for creation of mortgage, and another 10 days for registration of mortgage. So in all, another 2 months. Why I'm saying all this, my lord, we want to pay. My lord, we have got close to 100 employees in our payroll, my lord. And many of them have not been receiving their salaries. Even then, they are, my lord, discharging their duties, my lord. And they have also understood what has been happening. But the positive sign is that, my lord, we are likely to come out of this situation, my lord, very shortly, my lord. My lord, I have a copy of, my lord, this is confidential, but I can place before your lordship, my lord. This is the binding agreement that we have executed. Your lordship will kindly, my lord, find, my lord, borrower's name is there. Promoter name is there. Public or entity, so and so. And that investment amount, INR 245 crore at serial 6. The promoter will also have to infuse about 2.5 crore into the transaction first, and then they will pay, my lord. Then all these niceties, my lord, have been mentioned here. Repayment schedule, my lord. The next interest, default interest, equity put option, security is mentioned, my lord. Then riders have been given, my lord. Other terms, representations, warranties, covenants, etc. have been given at serial number 20, my lord. So these are the terms and conditions, my lord, and to that end, my lord, we have almost done everything except, my lord, these 4 parcels of land, my lord. These are the deed of sale, my lord. I have copied, my lord. If your lordship wishes to see, my lord, I can place, my lord. But this online process is taking some time, my lord. And for that, my lord, we require some time. We are ready to pay along with interest, everything, my lord, whatever is there. We also understand that the decree is there. And by your lordship's interim directions, my lord, we have been able to do it till date. On 14th of August, my lord, that agreement, that binding agreement has been executed.
Now, what is your prayer?
My prayer is that, my lord, I be given 2 months' time, my lord, or at least 45 days' time. Actually, we want 45 days for, my lord, to get this, for the permission, my lord, to mortgage, to create the mortgage before the registry, my lord.
Hmm.
Now we have to get permission to create this mortgage, my lord, nowadays, and this is also done online, my lord. We have to upload the other documents. And thereafter, my lord, this 1 week maybe, my lord, 1 week or 10 days at most, my lord, for registry.
So, your prayer is
45
to
days
grant
for-
45 days time to you.
My lord.
Yes,
Okay.
other side.
I hope my friend will understand, my lord.
I have not
know
understood.
They have got a decree in against husband.
Lordship, if I'm going to understand their claim, then my client will be suffered, and he's suffering. Your Lordship, this was a suit. Title suit for ejectment as well as for area rent. He was my tenant and he is my tenant. And I filed this suit for ejectment. He filed a written statement admitting that he is a defaulter in payment of rent. So on admission, there's a decree. That decree has been passed. Before that, they preferred revision that was withdrawn, and earlier revision they were directed, before passing the decree, they were directed to deposit an amount of 30 lakhs. Admittedly, they are not paying the rent till today. So thereafter that revision was withdrawn, and thereafter decree was passed. And after the decree being passed, they came before this honorable court before this appeal. And they filed an application for stay. And they have obtained the stay on condition that they will pay the amount as directed by the honorable court. They have not paid it. And ultimately that stay is vacated. What happened? And we proceeded because the court has directed that if they are not paying, that the executing court will do the needful. Accordingly, executing court proceeded to execute the writ of execution. Immediately they filed an application therein, and that application rejected. Against that, they preferred an IA in the pending appeal. And in pending appeal, yes, my conscience will be clear from the order dated 16/5/2024. Thereafter 4/6/2024, and thereafter 7/6/2024, and 18/7/2024. In every occasions, they are claiming, they are seeking time to pay the amount. It's not a money suit. It is not a money suit that attachment is to be made and money is to be recovered. It's an ejectment suit. It's an ejectment suit. Interim order was passed, giving direction to the appellant to pay the amount. You pay it. They are not paying it. Rather, they are time and again seeking time before this honorable court, making those statements. Today, they filed this application. Listen. Today, they have filed this application seeking another 2 months' time. Last order has been passed. If they are not going to deposit the fixed amount, that is 60 lakhs and or more than that, that order will be automatically vacated. That was the last order. Last order, Your Lordship. There was also earlier also there was an order.
It is quoted in our affidavit. Para
18/7/2024. Last order. The matter is fixed for hearing on the main appeal. I am not on the stay. I am not on the stay. Because why stay is required? During pendency of the appeal, decree is not to be executed. Matter today is fixed for hearing of the appeal. Then stay is till today. Then why stays to be heard? The matter to be heard. Why the another time is required? 45 days, 2 months. Now they are making these statements. They will get. In the earlier application also they say that they will get without document. Today also without document they are saying that 245. Why shall I wait for them? Why the honorable court shall wait? It is in two parts. One is ejectment part. One is recovery realization area rent part. I will recover it. Let them vacate. Because They are not paying the rent, they are not depositing the rent, they are occupying the premises illegally without paying a single payment. Since 2018, crores of rupees, more than 2 crores has been passed away, the area rent is dues. More than 2 crores. And time and again, they are filing the application. Why the Honorable Court will allow to suffer the landlord at the cost of the landlord, while they will enjoy it? Who is a defaulter, rank defaulter? It will be president. So my submission before this Honorable Court, no further time is necessary to be granted, rather the matter to be heard today itself. Because admittedly, they are going to pay the amount. What amount? Area rent. If area you are liable to pay the area rent, you are defaulter. That the decree was passed, if the compromise decree on the ground
No,
of
decree was passed on admission.
admission,
Yes.
then what remains to be? The appeal to be dismissed. I will be allowed to execute the decree. Why shall I wait for him? Why the Honorable Court would allow the plaintiff to suffer without getting a money, without getting the rent? Today they are saying they will get 245 crore rupees for that so and so, so and so. I do not know. It is a confidential document. If it is a confidential
I
document,
have placed it before the court,
No.
my lord.
no, it is not necessary. I am not with the, I am not with them.
I have not annexed, my lord.
I am not with them, your lordship. I am with my client. I am with my tenanted premises. I am with the tenant premises. I am ready to hear the matter. And matter is admitted. What nothing to be heard in the appeal, because they are going to pay the amount. Why you are going to pay? So area rent is due. So you are defaulter. What remains to be proved? What wrong has been committed by the appellate court in passing the decree on admission? So my submission before this Honorable Court, I am not on the state that the decree is to be affirmed and the appeal to be dismissed today itself. Why the matter will be dragged, allowed to be dragged for another 2 months when there is an admission decree? That will be precedent. And they are doing it. They are doing it from the filing of the appeal, from the date of filing the appeal. Time and again, order is vacated. We went for execution, but again they came, thereafter they obtained the stay order, and last order, your lordship. Ultimately, there's a speaking order that if you fail to deposit it, the stay order ultimately get vacated, and it will amount to review. It will amount to review without their having any application for review. So my submission before this Honorable Court, the appeal to be dismissed, nothing to be stay order, nothing to be considered. When the matter will be decided by the Honorable Court, it will be finally decided. That is my submission before this Honorable.
Well, if I may reply, my lord. Your lordship, the facts are, my lord, admitted. My lord, they went to the court when, my lord, there was a default on our part, my lord. So basically what they want the money, and we are agreeable to pay that, my lord. For that, we have made an arrangement. My lord, it is not just a matter of a few lakhs or anything, my lord. Not only the premises, my lord, owned by the client of my friend, my lord, but there are hundreds of employees, my lord, whose fates are also involved here. They are continuing it with the hope that, my lord, after this agreement has been executed on 14th of August, my lord, this is final stage, only the collateral we have to make it. Everything is fine, my lord. The process is going to take time. Thereafter, with interest, they are going to get paid, man. And there is no dispute on that, man. What they are seeking, my lord, what they sought in their plain, my lord, they are going to get it, man. My lord, if I may say, my lord, there is some amount of public interest is also involved, man. And on this, my lord, in this background, my lord, the order was initially granted by this court. My lord, this court could have granted a 6 months time.
How public interest is involved?
My lord, these employees are there, my lord. Their families are concerned, my lord. It's a cement factory, my lord, cement plant. And this has been inspected by the would-be sponsors, man. The financier, reconstruction bank. This is the final, my lord, binding contract, man. Only thing, my lord, that collateral has to be made ready by us, for which, my lord, work is already going on. And the competent authorities have made the processes more intricate nowadays, my lord. You know, time is given for this and that. We have to upload in the system. So that is the reason why it is taking.
No,
not otherwise.
uploading of documents will not take much time.
My lord, uploading will not take much time,
Then-
but for verification, it will take time.
Hmm.
But that I have stated in my para 3, man.
Hmm.
Now, we have no pleasure in, my lord, delaying the payment or going on ahead with this litigation, man. We are in a state, my lord, from where we cannot come out by ourselves, man. We need someone's help.
Hmm. So
Since-
wait for some days.
My lord,
Lordship,
they have already
Lordship.
converted, my lord.
Since 2018, I have seen. And my,
No,
it is
no,
out of
if-
court, or
if,
it is out of
no, no,
court.
no, no.
It is, I can submit,
no,
your,
okay.
my friend,
No, no, if he is ready to pay the interest.
he's not going to
then-
pay it. Because my friend submitted before his honorable court, he personally asked me that he will not appear
I
if
will,
he's not going to pay it.
I will not submit something, my lord, which is not going to happen, my lord. With
So
my instruction,
why-
I am appearing today.
Yes. Why, Lordship, why the plaintiff would suffer?
No, no, now he is agreeable to pay the interest also.
Yes, my lord.
Not only
But
the,
It
I
is,
have to pay.
it is not a purely a money suit.
no, that's all right.
Why he is not allowing me to execute the decree?
Hmm.
For the realization of the amount is a separate part. So for the execution of decree in respect to premises concerned eviction part, it's a different part. He will pay it. I have no doubt about it. He will pay it. When there is a decree on admission, why the honorable court will wait to execute that part? Because he is admitting that I am not paying it. Till today, I have not paid the area rent. That means default are admitted. Under that circumstances, whether that person shall be allowed to stay. I will execute the decree. I will realize it. When there is an admission that he is a defaulter, then since 2018, my client is suffering a lot. Since 2018, not a single penny he is
So
receiving.
wait for another 4 weeks.
4 weeks.
Hmm.
My lord, for
He will
45
pay the
days.
interest.
45 days.
Lordship, Lordship, I openly submit before Honorable. I'm not going to receive
No,
the
no,
amount.
that's all
They
right.
are taking
but,
the time. They are
you
giving the
have-
time.
No, no, you have traveled with him a long way.
Yes.
My lord.
You have
They have
considered
forgotten
it
that.
on your considering the learned, or no, this court was pleased to extend the time till date.
Yes. Till that.
Hmm.
On that though, we have objected it.
It is my friend's greatness, man.
That is why the order has been passed. If this order is the order passed, it is automatically
No,
vacated.
now let us believe his words. He has shown the agreement also that he
It is
will be
agreement, it
getting-
is some other persons, your lordship.
Pardon?
So some other persons along with third party, it is not agreement with, it is not.
No, that's all right.
Yes.
But he has
This
produced it
fact-
for perusal of this court that something is going on.
Now, what will be the consequence, your lordship? I am submitting before your lordship that it is in respect of payment of the amount,
Hmm.
realization of the area rent,
Hmm.
and the ultimately that area rent will be realized by the executing court.
Hmm.
It is the open to the executing court.
Hmm.
They were directed to make the payment. They are not going to make the entire amount. They will pay the amount for granted for as directed by the honorable court. Now, when it is admitted that we have not been paying the rent,
Hmm.
that what remains to be proved in the appeal?
No, no, we are not on the merit of the appeal.
Today is a hearing for appeal.
Hmm.
Today date is fixed for hearing of the
No,
appeal.
if both the parties are ready to argue the matter,
Then I am ready.
This court is
I am
also
ready.
ready.
I am ready.
Court is ready to hear the matter.
I am ready.
Well, I am making a prayer, my lord, under the peculiar circumstances of the case.
Mm.
My lord, agreed, my lord. The hearing is done. This appeal is lost, my lord. What happens, my lord? They will evict us. They will require at least, my lord, 2 to 3 weeks time, my lord. That is my lord, to require man and material and everything, my lord. And then all things have to go out. And then there will be a delay in payment of the money. Then again, they have to go ahead with the. Let us avoid all these things, my lord. I am agreeable to pay. They have already relented, my lord. Your lordship, this is a binding contract, we cannot get out of it, my lord.
So
Or they cannot
regarding
get out.
vacation of the premises,
My lord,
you have to vacate the premises.
my lord, if they get the money, my lord, they filed the suit, my lord, money suit.
No, money suit. This is ejectment suit.
Ejectment, my lord, because of what, my lord? Thinking that we will not pay. Actually, the situation was that we are not in a position to pay. And still that is existing, but hopefully that help is coming. So once they get paid, they can enhance the rent. They will be able to enhance their rent under the agreement, whatever I do not know, my lord. So that is not a material point, my lord. But the money we owe them, that we have to give. And if they want to keep us there, my lord, further, there may be some different with enhancement in the rent.
No, no, that is a matter of compromise. I am not on that. I filed this suit for ejectment, as you have defaulted in payment of rent. It is not, I have not filed this suit for only solely for money. I want to eviction. I want eviction of that tenant. That is appeal. I not filed this suit. I did not file this suit for realization of the money only. That he is not paying the rent, money is to be paid. That the law says if a tenant defaulted, he is liable to be evicted. Agreed. He agreed that I have not paid the amount. Why shall I wait? Why shall I enter into another agreement with him? That is a matter of compromise. That is a different thing. He paid some amount by check that was bounced. I am not, it is on the record. That is the conduct. Why we are opposing it? Because of their conduct. Earlier conduct.
Yes, Mr. Goswami.
My lord, I would like to pray, my lord, that this time be granted, then things will settle down every night. We are working only to that end, my lord. These submissions are not new, my lord. Except this agreement, my lord, execution of this agreement.
No, it
Submissions
appears
were
that
same.
Mr. Goswami, your conduct appears to be not at all satisfactory.
I agree to all that, my lord. I agree to, because we cannot get out of, my lord, the material that is available to the court, my lord.
Mm.
And I'm also grateful.
And because of your conduct, last chance is given today.
My lord, actually before that also it has been extended from time to time, my lord.
Mm.
Only on this, my lord. Now this binding agreement has been made on 14th of August this month, my lord.
Mm.
So rest, my lord, only this creation of mortgage has to be done, my lord. Other things have been already done, my lord.
Mm.
And that, my lord, on affidavit I have brought in before your lordship. So only on the basis of that, my lord, I pray for some more time. My lord, so far as we are concerned, there is no lectures on our part, my lord. We have been trying, my lord, everything.
September 23.
Check was paid, that was bounced. Lordship, there was another IA, that is 2945 of 2023.
Mm.
In para 2 of that IA, what they have stated, para 6, the petitioner submits that the petitioner's company was suffering. I am reading out. Paragraph number 6.
Not necessary. You try to try to work out the solution.
Lordship.
Mm.
Then at that I application, they have stated it was filed in 23 September. And what they have stated, 2 months time is required.
So, Mr. Goswami, can you complete the entire process within 4 weeks?
45 days, my lord.
No,
45. Or your lordship can monitor, your lordship can keep it.
those monitoring is not required, not within the purview of this court.
We'll
Lordship.
keep this status, my lord, as today, my lord, we have stated, my lord.
Mm.
Whatever progress that we make by the time. and
Yeah,
then your
yeah,
lordship
no,
will
no,
decide.
no, no. After 45 days, again you will come that
Yeah, Lordship,
it is
definitely.
about to complete.
No, but
Yes.
that was never the intention, man. That was never the intention.
That what will be the consequence at when he will come again?
Your lordship will kindly allow us 4 weeks time, man. We'll bring this status, my lord, what happens.
Status will not.
No, on that basis, my your lordship will at least see whether we grant us
Status
further time or not.
from that status report.
But my lord, very conservative assessment, my lord. 30 days plus, my lord, we have stated in our in this rejoinder affidavit, my lord. Your lordship will see at page 3, my lord.
After 4 weeks, definitely, your lordship, they will come with a status report. And another 4 weeks will come.
No, my lord.
This company, lordship, paragraph number 3, the mutual funds, as informed.
My lord, to be verified by cycle officer at page 3, my lord, Sonarpur and forwarded to the office of the district commissioner for issuance of NOC for the creation of a mortgage before the sub-register, which require another 45 days for NOC. And for creation of mortgage,
NOC.
Oh, NOC.
Then thereafter.
There will be.
No, first tell me whether against a compromise decree appeal lies.
No. No appeal lies.
Then how it is admitted?
No appeal lies.
How it is admitted then? How stay was granted?
No, my lord.
At that time, we were not.
My lord, this appeal was admitted with conditions, my lord. The order that was passed on that, it was also on condition.
No, whether such a
But the
situation is
consideration possibly, my lord, I was not there at the moment, my lord. Consideration possibly was the same consideration, this human consideration, nothing else.
Human.
Otherwise, your lordship is aware about the law.
My party is not a human lordship.
No, he is going to get whatever.
Anyway, Mr. Goswami, you have to complete the process within 4 weeks.
4 weeks.
4 weeks. No further time will be granted.
No further.
Can I just pray for 45 days, my lord? 45 days.
No, no 45 days.
My lord.
You comply with the court order
My lord.
or face the
And
consequences.
appeal maybe we record the part heard, lordship.
Yes, my lord.
Heard Mr. B.D. Goswami, Learned Counsel for the appellant, and Mr.
R.K. Bhuiya.
R.K. Bhuiya, Learned Counsel for the respondent. So you have filed the affidavit in the IA.
I am.
Mr. Goswami, Learned Counsel for the appellant, submits that he has filed and rejoined the affidavit today. And he prays for granting him 2 months' time for payment to the judgment debtor. Mr. Goswami producing one agreement, that is agreement,
This is called binding agreement, my lord, dated 14th of August.
one binding agreement dated 14th of August 2024
Executed with the reconstruction agent, your lordship,
with the
reconstruction agent. Edelweiss name is there. Edelweiss Alternative Asset Advisors Limited. Mumbai.
with the Edelweiss Alternative Asset Advisor Limited, Mumbai. And submits that within 45 days, the entire process will be completed, and therefore Mr. Goswami contented to grant in 45 days time. However, Mr. Bhuya, learned counsel for the respondent, has vehemently opposed the same. Mr. Bhuya submits that conduct of the appellant is not at all satisfactory, and on such count, no time may be granted, and the appeal may be heard and finally disposed of. However, considering the submission of Mr. Goswami, learned counsel for the appellant, and also considering the affidavit submitted before this court is inclined to grant another 4 weeks time to make payment of the to make payment of the dues to the judgment debtor. This is a list the matter after. Let us fix it at
Date, lordship.
On 26 September.
26.
26 September. And it may be across the part.
Okay. I feel heard Mr. Simpson. List the matter again on him for further hearing as parted.
Item 13.
Milord, I have a prayer, Milord. Can this matter be taken up in the second week of September, Milord?
Why?
I have to go through the matter, Milord.
So when you have been engaged here,
Restructure the file, Milord. So I just require some time, Milord. I inform the other side also.
Lordship, it's a very old pending matter, lordship. It's of 2012, lordship.
yes. Mr. Customer, learned counsel for the appellant, with consent from the other side, press for listing the matter. Suggested it.
On 1st October, Tuesday,
Short date.
19 September. Item 14.
I put affidavit. Three subsequent question of law was framed. Recently on 21/5/24, 21 at the time of hearing. Whether the learned courts below were justified in decreeing the suit in favor of the plaintiff in absence of any document of title being exhibited within accordance with law. This is the first subsequent question of law. Second, whether findings arrive at the learned trial court that the plaintiff has right title interest over the suit property suffers from perversity in view of evidence and record. And earlier on 18/12/13, whether title suit number 10626 is maintainable in view of the provisions contained in Order 9 Rule 9 CPC, as the earlier suit being title suit number so and so was dismissed for default. In other words, whether for the same cause of action a fresh suit is maintainable when earlier suit was dismissed for default. This was a subsequent question of law frame. What the court has, the appellate court has affirmed the decree of the trial court. The trial court has granted title interest in favor of the plaintiff and recovery of cost position. Also, you may see the plaintiff.
So what was the earlier first question of first substantial question of law?
That on the basis the Lalet trial court on basis of a judgment and decree
has decreed the
No, no, what was the first substantial question of law?
Whether the title suit number 106 is maintainable in view of the provisions contained in Order 9, Rule 9, as the earlier suit was being title suit number 75 of 1970 was dismissed for default. In other words, whether for the same cause of action, a fresh suit is maintainable and the earlier suit was dismissed for default. If your lordship see the plain, I will make you understand. The plain, page 67 in my affidavit. File on 18/6/24, because the earlier the plain was some mistake. So I filed a fresh translation on 18/6/24. Page number 68. Of my affidavit, file on 18/6/24. Got it?
Yes.
What is the case of the plaintiff is that the plaintiff has filed a suit claiming 1/3 part of the land measuring 1 biga 2 kothas 6 licenses of dark number 874 periodic photo number 394 pertaining to a 1968 citizen survey, Ismot Town, Nagaon, was a town within the jurisdiction of this land. A retail description of land has been stated in the schedule below. A certificate of Jamuni in respect of schedule has been submitted. The plaintiff is having right and interest of the land described in the schedule below. While the plaintiff was enjoying the possession of the suit land by her own right and title, plaintiff number 1 had to go to Kaki for some days in order to look after the agriculture there. Taking advantage of her absence, the principal defendants constructed a house on the suit land on 1/3/1979. This compelled the plaintiff to file a title suit number 75 of 1979 in the court of Munship at Nagaon. The plaintiff number 1 obtained an ex parte degree in the suit on 25/2/81. As per the opposite degree on 10/9/81 in the title suit, execution case number so and so, the police, Dortmund and others evicted the husband debtor from suit land by demolishing the disputed house and delivered possession of the plaintiff. Accordingly, the plaintiff continued to enjoy possession of the suit land. That after the suit land was handed over to the plaintiff as stated in the preceding paragraph, the plaintiff number 2 and 3, due to their marriage, had stayed outside and taking advantage of the old age of the plaintiff number 1, the principal defendant once again transfers in the scheduled land on 4/10/96 and construct houses thereon. When plaintiff 1 objected to the activities of the defendants, they said that they shall vacate the suit land on 5/1/99. That as the defendant stated, they shall vacate the said land, and being the close relative of the plaintiff number 1, she believed it easily. But later on, the defendants, under the pretext such as they will vacate the suit land today or tomorrow, but they did not vacate the suit land and denied the right title of the plaintiff on 10/8/2003 over the suit land. The plaintiffs are having the right title of the scheduled land mentioned below. In the earlier title suit number so and so, the court declared plaintiff title in respect of suit land and also delivered a khas position thereof in their favor. After the aforesaid decree and taking position of the plaintiffs have not sold or transferred the aforesaid land to any other person. The defendants denied the title of plaintiff in the suit land and forcibly took position of the scheduled land, have clouded the plaintiff title in respect of the scheduled land. This is a compelled plaintiff to file this suit. And the schedule is land measuring the schedule is land measuring 2 kotha 12 lesas, but a degree was given in respect of 2 kothas 16 lesas, 4 kothas more in the trial court, which was affirmed by the High Court. And what has happened after this? In the memorial appeal, page 31. Appeal was filed by the defendants. The relevant portion is on page 32. Sorry, page 33, the bottom part. 33 bottom part. But whatever be the position, whether not or does, this court in deciding the petition for condemnation relay in filing the appeal decided that the defendant appellants cannot be held to have knowledge of the suit. That being once decided, I find no means to go back now and
Which,
decide
which
otherwise.
paragraph you were reading?
Paragraph, page 33 and below part. 6 line above. But on the bottom. But whatever be the position, whether not or does, this court in dealing the petition for condonation of delay in filing the appeal decided that the defendant appellants cannot be held to have knowledge of the suit. That being once decided, I have no means to go back now and decide otherwise. It also appears that the learned court did not write a judgment as required by law. That the defendants did not appear or contest the suit is not ground for a decree in favor of the plaintiff. The plaintiff must prima facie prove his claim, and then only the suit could have been decreed. It appears that the learned court did not care to see the requirements, but wrote an order in her order sheet itself decreeing the suit. The issues were not able to discuss. Hence, I feel that the expertise judgment decree of the learned lower court should be set aside and appeal may be allowed. Accordingly, I ordered that the appeal be allowed and expertise judgment decree of the learned court be set aside and the suit be sent to the learned court for inter-party trial after proper service of summons. That the parties to the appeal are however left to bear their own cost. After that, the suit again sent back to the trial court, and it was the defendants, the plaintiff did not appear, and was dismissed for default. On the basis of this earlier order, the judgment on Title 75, the learned trial court has passed the decree. And page 40. Issue number 3. Whether plaintiff has right title interest over the suit land. Exhibit 2, 3, and 9 in the present suit clearly shows that the present plaintiff has title over the suit land. In Exhibit 9, being the 11% of mutation copy, shows in a clear manner that the name of the plaintiff is muted in DAG number A74, pattern number 394. Exhibit 2 and 3, on the other hand, shows the order of the court delivering the possession of the land to the present plaintiff in the year 1981. The exhibit clearly shows that the plaintiff has title of interest over the suit land. There are no dispute in regards to facts that the possession of the land was conferred to the plaintiff by the court itself earlier. In view of the facts involved in the suit and the exhibits, that remains no doubt that the plaintiff has a bona fide right over the claim CS made over the suit land as mentioned in the schedule of the claim. To add further, the plaintiff fairly and in a sincere approach claim 1/3 of the share at total land of considering 1 bigha 2 kota 6 lasas, which stands as 2 kota 12 lasas of land. And as such, and as mentioned above, the title of plaintiff is very much explicit over the claims being made on the respective share of the land. This issue is accordingly presented in affirmative and in favor of the plaintiff. And the order below. In the result, the present suit of plaintiff succeeds, and the suit is decreed in favor of plaintiff, which cause the plaintiff are entitled to get the possession of the share of the land amounting to 2 kotas and 16 lasas of land in pattern number 1394 under the DAG number A74 under the Nagaon on Moja in the Nagaon Kismat. A decree is accordingly prepared. So the land trial court has given the plaintiff claim for 2 kota 12 lasas. The land trial court has given 2 kota 16 lasas. Also, decree was prepared according to it was prepared for 2 kota 16 lasas. Prayer number 48, the decree, the 11th part of the decree. Page 48. The possession of over the share of the land amounting to 2 kotas 6 lasas of land in patta number 394 under the DAG number so. So the land trial court has decreed more than what they are claiming, 2 kotas 16 lasas. They have claimed 2 kotas 12 lasas. They have decreed to 2 kotas 16 lasas. And in the appellate court also affirmed the decree of the trial court. Paragraph number 18.
Page number.
Page number 59. Widow 3, in our evidence stated that the suit and originally belongs to her father. Plaintiff witness denied the transfer of suit land in favor of property by Dhaneswar Das. Exhibit 4, the Jamapati copy of the suit patta for 1957 settlement period shows the name of Dhaneswar Das meted along with the other patta by right of purchase. Patta also shows that there is one Dhaneswar Kavitra and one Dhaneswar Das shown as a patta of suit land. And name of Dhaneswar meted in the suit patta by right of purchase as per Exhibit 4. On 29/8/63, by petition number so and so. Thus, the Dhaneswar sold the land in Nayanipur does not carry any strength and force. Defendant admitted the suit on to Dhaneswar Das. Ancestor of the plaintiff therefore has right of inheritance when transfer of land measure 2 quotas is not proved. I find the plaintiff has got right title in interest in as far as suit land by right of inheritance, and issue is decided accordingly in the plaintiff favor, and no interference with the decision of the Learned Munsif is called for. So, they have not adduced any title document such as sale it, because as per Exhibit 4 of their document, the whole 1 bigger 3 plan is all are joint prototypes. The predecessor interest of the defendant, Kuleswari Kovator dam is there in 1952-55 as a pattadar. Now, also you may see the evidence of PWD 4. Place one must have given in maybe the record ago. That's what I said. Yeah, I think that could be answered. It was really good. It's in
No, itu বন্ধ করে দেওয়া যাবে না, এটাই বন্ধ করে দেওয়া যাবে না। বাইরে তো দিবে, তাহলে বন্ধ হবে। আচ্ছা, ঠিক আছে, হলো।
PW4, no, official witness. Raghunath Buru. LOC got it?
Mary, is it?
Yes.
I have received summons and appeared with the 11 documents. From the Jab Jammundi of 1957, 1958, it appears that pattern number 24 is renumbered as pattern number 357. The old Dag number 427 is renumbered as 460. The area of the land was 1 bigha, 2 kathas, 16 lasas. Total area land 1 bigha, 2 kathas, 16 lasas. The Pattadar, Dhaneswar Kobetro, Someswar Kobetro, Jetuka Kobetro, and Nimati Kobetro, Lutufar Rama, and 6 Fulesari Kobetro, the predecessor of the defendant. Fulesari Kobetro, wife of Jogendra Das Das, important. The 5 and 6 numbers were newly included in the settlement. I have also produced the 1960, 66, 68, 68, 69 draft SITA. In this SITA, old Dag number 460 was converted to Dag number 874. The old pattern number 357 got converted to pattern number 394. The area remained 1 bigha 2 kathas 16 lasa as before. In place of Dhaneswar and Jaluki, the successor, Dhaneswar was the, they claimed that they got the right from Dhaneswar Das. And their successor, Meloswari, wife of Dhaneswar, got newly inserted in the record. Exhibit 9 is a certified copy of the draft SITA issued by the office number so and so. So, in the Pata, the official witness has said that originally 1957-58, this predecessor of the defendant is the Patata, serial number 6. Fuleswari Kobetro. Your Excellency, Exhibit 4. I have tag marked next Exhibit 4. I have only some written in my note. The Jammundi AR 1957-58. Pattern number 357, Dag number 460. I see. You also got it?
Yes.
Jammundi from the year 1957-58. Pattern number 357, Dag number 460. This the serial number given at Dhaneswar Kobetro, Jetuki Kobetro, Nimati Kobetro, Mohod Lutfur, Fuleswari Kobetro. In serial number 5. Fuleswari Kobetro and 6 ko Dhaneswar Das. This is the plaintiff claim right from the Dhaneswar Das. 6. Our is Fuleswari Kobetro. 96, there is the order given in the side. 1962-63 sonor 2225 nong Namjori Hukum Mote 29/8/63 Hukum Mote Potter 860 Agor Onghot 2 kotha balasa Koitar Hutre Dhaneswar Kobetro U Potter Logot Sri Dhaneswar Dafor Namjori Hoy Potter Nam Samil Hoise. But no any document of sale deed was exhibited by them. No any patta was exhibited. But as far this Exhibit 4 and the evidence of the PW4, the Fuleswari Kobetro was the part of the from their own documents. Exhibit 5 is the Jammundi of 1930-31. It is Dhaneswar Kobetro. Name was there. And Exhibit 6. Exhibit 6, there is name of Dhaneswar Kobetro and Fuleswari Kobetro. And other 4 there, name is there. In the of the year 1957-58. Pattern number is 254 new, 360 old, and new one 357, and Dag number is 427, 460. Also in Exhibit 9 also, on the basis of which the appellate court has declared a suit in favor of the plaintiff. The Fuleswari Kobetro name is on
serial number 5. This of 1968, 69 Jamamati. Exhibit 9. Got it? So from the exhibited documents by the plaintiff, our name is there in 1957, 58. After that, their name came by way of sale deed. Here in this case, no sale deed was exhibited as a title document, no any patta was exhibited as a title document. See page 71 of our plane. I have to point out one something. In the affidavit, page 71. File on 18/6/24.
Yes.
If you, this land measuring 2/12 SS, and below there is a boundary. What is there claiming land of measuring 2/12 SS? But the order given in the trial court is 2/16 SS. And in the boundary, if you see your lordship, the boundary of land are north Forgaswar Das and Dharmeswar Das, south Fuleswari land. Fuleswari means the predecessor of the defendant. Sorry, of the defendant. So, and in the PW3, one of the plaintiffs, PW3, she has stated,
Is part of the appeal memo?
no, in the
PW3?
Lower court record there is a PW3. Lower court record.
When PW3 was examined?
You know, examine 27/7/2005. PW1 died without giving any after evidence. He died, so there's no constitution of PW1. PW2 is just is one of the 20 entries. What I am stating in the lower court record, PW3.
Yes.
I file evidence on affidavit. My father's name is Maheshwar Das. I do not know the pattern number or dark number of suit land. The suit land measuring 2/12 SS. I don't know how much land is there in the suit patta. The suit land originally belonged to my father. I don't know how much land in all my father possess. I do not know the boundary of the suit land. I have not visited the suit land. I do not know Fuleswari Das. I do not know whether Fuleswari Das is a grandmother of the defendant, Hemandas or others. I do not know the name of the father of the Hemandas. Earlier, my mother has filed one suit. I do not know whether suit was numbered as TS 75 1979 and was instituted against Pulsari Das. I don't know whether TS 79 1989 was declared expert in favor of my mother. I do not know whether the election freedom was instituted by my mother. It is noticed fact that the exam of degree could not be completed on 10/9/81. It is not whether an appeal was preferred before the civil judge. Now against the execution, I don't know whether the expertise degree was set aside by the civil judge. The case was remanded to the court of Munsif. It is not a fact that during court of Munsif, our case was dismissed. I do not know whether suit was again revived. I do not know whether suit was again dismissed for default. It is not fact that on same cause of action, we have filed this case after several years of dismissal. It is not fact that my mother sold the 2 quotas then in 1952 Pulsari Das by means of research held it. It is not a fact that since 1954 defendants are in possession of the Suitland. It is in a fact that in the plain I have shown that on the south of Suitland there is land of Pulsari Das. It is a fact that in the plain I have shown that on south of the Suitland there is land of Pulsari Das. It is not a fact that defendants are in possession and ownership of the Suitland since 1954. It is not a fact that I have deposed falsely. Learned trial court, Your Lordship, on the basis of the earlier judgment in 75-79, which was set aside, has come to a conclusion as per in the trial court decree. On the basis of exhibit 2, 3, and 4, which I have stated that our name is there as a patadar in CL number 6 and CL number 5. And after that, CL number 6, there is an order in the reflected the exhibit 4 as Jamamundi that Dhaneshwar Das has purchased the suit land. Purchased the suit land on the basis of all the purchased land, the name was mutated. So as far their exhibit 4, no sale was exhibited, no any document title was exhibited. Only Jamawati does not confer any right upon the party. It's only payment of revenue. There is no document of title. In the exhibit 4, exhibit 9, exhibit 6, and in the PW4, everywhere PW4 stated that children 1 to 6 is the Pulsari Kobatoni, was the patadar. And the law trial court has given more what they have asked for. They claim for 2 quotas 12 lessons, land has liquidation for 2 quotas 16 lessons, 4 lessons more.
Yes.
The contention of the defendant is in paragraph 19, page 75 in the affidavit filed by me. Page 75 of affidavit.
Yes.
The real fact is that the owner of suit Patadar late Dhaneshwar Das and Dharmeshwar Das,
Which paragraph you are reading?
paragraph number 19,
Yes.
page 75. The real fact is that owner of the suit Patadar late Dhaneshwar Das and Dharmeshwar Das, husband of plaintiff number 1 and father of the plaintiff number 2, 3 and 4 have been in need of money, so it does for which 205 registered sale deed number so and so on 2354 and delivered her the same. And since 2354, Fuleshwari had been enjoying possession of the said and measuring 2 cutters by constructing houses, extra with tin roofs, wooden walls, etc., and growing various plants and trees thereupon by paying revenue as per law. As Fuleshwari has no son, the principal defendant number 1, 2, and 3, who are grandchildren from her daughter's side, are residing with her Fuleshwari for many years and enjoying the possession of the suit land. That after the death of Fuleshwari, apart from the other properties, the defendant inherited a said 2 acres land. Since the defendants have title enjoying possession of the suit land as such, the suit of the plaintiff is liable to be dismissed. The principal defendant number 2, Puna Das, has sold 13 acres of land out of 2 acres of land having right title and possession of the defendant number 1, 2, and 3 to the defendant number 5, Debojani Das, by registered deed number 268 dated 21/1/2000 and handed over the possession. The defendant number 5 has permanent house on the said 13 acres of land and is living with her family. Except the land measuring 13 acres sold by defendant number 2 to defendant number 5, the defendant number 1, 2, and 3 have their permanent houses in the remaining 1 quarter 7 acres of land, and they are living with their family by paying revenue as per law. In the schedule of the deed, from which Fuleshwari had purchased the said 2 quarters from Dhaneshwar, alias Dharmeshwar Das, Kismat was wrongly written as Harbour instead of town Nagaon. But that mistake cannot accept Fuleshwari right in respect of land. According to the 1931 census, the said 2 crore falls under Rang number 427 and Miadi Pat number 255. And only 1957-58 census Dag number 460, Miadi Pat number 357. And according to 1968-69 census Dag number 874, Miadi Pat number 39. It may be mentioned here that the plaintiffs, without having that pen poison out of gate, allegedly filed Tanusut of 2027, Tanusut 75-79 in the municipal court to evict Fuleshwari from 2 quarters out of 12 quarters of land owned and possessed and purchased by him. And due to that of Fuleshwari during the pendency of the suit, late Rajakanta Das, father of defendant 1, 2, 3, and defendant number 1, Srihan Das are made parties the suit. But the defendant Hemant Das did not receive any summon of the case, and he did not receive any summon by putting any signature without his knowledge. The aforesaid suit was decreed on ex parte on 25/2/81. As per ex parte decree, the plaintiff filed a title liquidation case number so and so without the knowledge of the defendant, Hemant Das. The plaintiff on 10/9/81, accompanied by police, Lord Model, etc., started demolishing the houses situated in the 2 quarters of land inherited by Hemant Das from Fuleshwari Das. At the time of demolishing some portion of the defendants, Hemant Das, surprised by it, protested against the demolition and stated that he has no knowledge about the suit and has not received any summons of the suit. Also a week ago, his son was born and he has no other
You
place.
see, by this additional affidavit, you were supposed to bring on record some documents.
No,
Plaintiff
plain and written statement,
Translated copy.
translated copy.
Pardon?
Plain and written statement, because in the plain and written statement filed with the memo bill, some of was from their mistake. So
How the facts, this statements made in your affidavit will help you, because we have to decide the appeal on the basis of record of the
yes, sir.
Monsif and the appellate court.
Yes, sir. Because the Tanusut 75 was set aside and was remanded back to the trial court. And this is for default. On the basis of this titles, earlier decree of the Tanusut, this the honorable trial court has decreed the suit. And moreover, the documents exhibited by the plaintiff are Jamabondi copies, which are not a title document. And in the Jamabondi copy and in the evidence of PWD 4, then our name is there, exhibit 4, 6, 9. There is a patta there, the predecessor of the defendant, Puleswari Kubota name was there. It is before them, our name is there. In 1954, 55, Jamamundi. Also, P24 also stated that our name is there in serial number 6 as a patta there, the official witness. The Jamaudism is not a title document.
Yes, that is settled proposition.
So as per PW4, there is an order in the PW4. As for exhibit 4, there is an order that Dhaneswar Das, because of his purchase, has got his land meted on the basis of purchase, but they have not exhibited the sale deed. Exhibit 4. Your Worship, see exhibit 4. Exhibit 4, Jamabudi year 1957-58. There is a tag mark given.
Thank you. Yes.
Lordship, got it? This Jamamundi of the year 1957-58. Our predecessor name, Puleswari Kuori name is in CL number 5. Lordship, got it? CL number 5, Puleswari Koibotto. 6 ko, Dhaneswar Das, the predecessor of the plaintiff, Dhaneswar Das. 6 ko. Lordship, got it? There is an order, right hand side there is an order given, 1962-63 sonor 225 number Namjari Hukum Namjari Mukadama Mote 29-863 Hukum Mote Potter 860 Dagor Onko Dui Kotha Barlasa Khoriddar Hutre Dhaneswar Koibotro Onno Potarar Logot Sri Dhaneswar Dak Namare Namjari Hoi Potat Nam Samil Thake means their mediation is in respect of sale deed, but here no sale deed was exhibited by them. And in our name is there is a patata in Puleswari Court in PCL 5. So at the time of hearing on 21/5/24, the court has asked them to follow what basis you claim there's a document of title to show them the document of title, but they failed to do so because only on the basis of Jamamundi. Our name is there is Jamamundi because there is a serial number 5 in the revenue records of there is a patta. Our name is there. In fact, because the defendant could not contest, only file WS could not contest that case because we have a registered sale in our name 1954-55. Because at the time the case was transferred to some other person, they could not contest and they should have proceeded ex parte against the defendant. But whatever the weakness of the plaintiff, so the defendant, the plaintiff has to prove his own case because from their own documents, from the exhibit given by them and their witnesses, our name is there in the Patada. Exhibit 4, 6, 9, and a PW4. And they have not given a single document of title. Only Jamamundi name is there.
Yes. Any other point?
Jitendra Singh versus State of Madhya Pradesh. Paragraph number 6. In case of Suraj Bhan versus Financial Commissioner 2007 SCC 186, it is observed and held by this court that the entry in the revenue records does not confer title on a person whose name appears in the record of rights. You also got it? Paragraph number 6. In case of Suraj Bhan versus Finance Commissioner 2007 SCC 186, it is observed and held by this court that an entry in revenue records does not confer title on a person whose name appears in the record of rights. Entries in the revenue records or Jamamudi have only a fiscal purpose, that is payment of land revenue, and no ownership is conferred on the basis of such entries. It is further observed that so far as title of the property is concerned, it is only to be decided by the competent civil court. Similar view has been expressed in the case of Son versus Union of India and so and so. And another is Bal Subramaniam and others, para 12. Para 12. Based on the various materials information, a petition was filed, Exhibit B3 on 29/4/1969 before the Assistant Sales Officer for activation or the mistake in grant of patta in favor of plaintiff vendors. Only in the context, Ramaswamy Konar appeared in person and informed the Sakapur that he has no objection to change the patta in respect of property in favor of the defendant's husband. Even otherwise, the grant of patta cannot be equated
So
to that
you
of
were reading paragraph number
12.
who is judgment?
Bala Subramaniam and others. Bala Subramaniam versus Ramaya Hondaman.
No, that judgment is you have not given to us.
I have extra copy. Paragraph number 12. Based on the various materials information, paragraph number 12, based on the various materials information, a petition was filed, Exhibit B3 on 29/4/1969 before the Assistant Sales Officer for rectification of a mistake in grant of patta in favor of the plaintiff vendors. Only in this context, Ramaswamy Konar appeared in person and informed the officer that he has no objection to change the patta in respect of property in favor of defendant's husband. Even otherwise, the grant of patta cannot be equated to that of a document of title. As the most patta proceedings and the ultimate order by competent authority granting patta may be issued as a piece of evidence to show that the subject matter is with grantee. Considering all these materials aspect, particularly the action of the plaintiff vendor in informing the Sales Officer about the wrong decision on granting patta in their favor, and considering the royal and documented evidence regard to the same, the lower appellate court rightly concluded the Sales Officer has passed an order which do not confer any right or title to the plaintiff's vendor, the said Ramaswamy Konar and Nasama. One more, what will be the witness of the defendant, the plaintiff has to prove his own case. 11/15. Not a single title document was given exhibited by them. R.K. Madhurjit and another versus Takela Bam Abung Singh and another. Paragraph 15. Under section 101 of the Evidence Act, the burden of proving of facts rests on the party which substantially assert in the affirmative all the issues and not upon the party who denies it. Those illustration B to section 101 of the Evidence Act 1872 is a pointer to the issue which it is as follows. Burden of proof, whoever illustrations as desires a court to give judgment that he has entitled to certain land in the position of B by reason of facts which he asserts and B he denies to be true, must prove existence of those facts. On whom the burden of proof lies can be ascertained by taking note of the fact as to which of the parties will succeed if no evidence is adduced given on either side. The burden rests on the party who fail if no evidence at all is adduced. The burden of asserting the case rests upon the party who essentially assert positively the issue raised. This burden remain unchanged and never shifts under anyone all circumstances as clearly indicated in section 101 of the Act 1872. The opposite rule pertains to burden of proof as a matter of law and pleading. The other aspect of the burden of proof is the burden of producing evidence. The burden of proof in this respect may shift throughout the trial. The distinction between the burden of proof as a matter of law and pleading to that of adducing evidence is a matter of primary importance. As alluded above, the plaintiffs came for declaration of their title and therefore it was for the plaintiffs to establish the title affirmatively. Whether a plaintiff asks for a declared degree, he must prove his or title and is cannot take the advantage of the witness or the defendants. Moen Mar Basilis Catholicos and another versus Amos Reverend Mar Polos. Year 1954, Supreme Court 526.
So your part is over.
Yes.
Any other point?
About the third substantial question of law. Whether findings arrived at by the Line Trial Court that the plaintiff has right title and interest of the suit property suffers from publicity in view of the evidence on record. Just payment 21/5/2024. Second. The issue frame on 21/5/24. Supplemental question of law. Whether the findings arrived at the Border Land Trial Court that the plaintiff has right title interest over the suit property suffers from publicity in view of the evidence on record. The plaintiff claimed 2 kota 12 acres land. But that learned trial court has decreed 2 quarter sections of land. If the defendant is evicted, say, if the defendant is evicted, what will be the other four lessons of land? Because the decrease of 2 quarters, 16 lessons of land, not of 2 quarters of 12 lessons of land. So the order is defective. Because in the schedule they have claimed 2 quarters 12 lessons, but order is given of 2 quarters 16 lessons. Also, as far evidence of the pedophilia and in the boundary given stated earlier, that the pedophilia stated that in the western or eastern part, that there is a land of Fulesori Coberto. In the south is land of Fulesori land, and so pedophilia is in a cross. So the schedule is not proper. Page 71 is the plane. South Fulesori land.
What is this exhibit 2 and 3?
2 and 3 this is the order of the early execution 75. This was set aside by the appellate court. Notice given by the executing court. And 3 is the report of the bailiff. After that, appeal was filed, and the appellate court has set aside the decree. Page 31 of the memo appeal.
Thereafter?
They have appeared, and after that they have brought the plaintiff remain absent in a suit of dismissal default. In paragraph number, page 31. Page 31. This is the appeal file, page 31, by the defendant. And the relevant portion is page 33. May I read?
No, not necessary.
And
but thereafter the
Suit was
chief again.
Suit was defeated again, because
Yes.
this is the order of 28, order of 11/183. This exhibit 2 and 3 is of 81. Page 34. See the date. Your Lordship will see the date.
Where is the exhibit 2 and 3?
2 and 3 is the record book. This is of 81. They have not exhibited the earlier decree of the title suit, nor the appellate decree. The plaintiff.
And when this first appeal was filed?
83.
First appeal was filed on
There was a delay in filing the appeal. Mm. 31 lordship. Appeal number 28 of 1981.
81.
After the decree was executed.
The order is given on 11/183, page 34. 11/183. Page 34, 11/183. Below is the date given. 11/183. Page 34, Your Lordship.
After execution of the decree, it was set aside.
But it was not the belief has in the middle has because there was a son born, new baby born, so it has left the from the suit then. This order was given on merit, not they have appeared on merit. The court has said that the plaintiff must primarily prove the plaintiff must primarily prove his claim, and all this would have been decreed.
Someone was not properly served.
No.
That was the issue.
In paragraph number page 34, page 34 is there. The plaintiff must primarily prove his claim, and then only the suit could have been decreed. It appears that the learned court below did not care to see the requirements, but wrote an order in the order sheet itself declaring the suit. So it was on merit it was given. The issues were not at all discussed. Page 34 is there. Hence, I feel that the expert judgment decree of the court should be set aside and the appeal must be allowed. On merit, this order was given.
Okay.
So I do file written argument if your lordship allow me.
When?
Some time may be given.
Copies out to the others.
Okay.
I'm appearing for the plaintiff, the respondent. I'm appearing for the other side also. There will be two
Let him file this written argument. Thereafter, you can argue the matter. And in the meantime, we have to translate the this evidence of PW 1, 2, 3.
Your lordship, one is not because one has he died after filing evidence. One, PW 1. Only 2 is required. 3 days is written in English. Only PW
3 and 4. 3 and 4 both are in English.
Yes, 3 and 4 are in English. One is not required because she died before.
Heard Mr. S. Gogoi, learned counsel for the appellant, and Mr.
SP Chaudhary.
SP Chaudhary, learned counsel for the respondent. Argument of Mr. Gogoi, learned counsel for the appellant is completed. However, Mr. Gogoi submits that he will submit written synopsis of argument. and press for granting him time. Pair is allowed. List the matter when.
First week of September, last week.
First week not
This is the
possible.
old pending matter, last week. Old pending matter on various occasions, the matter has been listed.
Many
Yes,
old
yes,
pending
that
matters
I
were
know, Lord,
decided.
that I know. That I know.
10th of September.
A copy may be served in you also, Lord.
Sir, sir, will
Written argument. No, he will furnish. And in the meantime, rest shall get the evidence of the PW 1, 2, 3, 4 typed, translated and typed.
4 is translated English, in English, Lord.
4 is to be typed. That is handwritten. List the matter as parted.
Please.
Item 16.
You are for
On behalf of
respondent
number 1.
Respondent. None appears for the appellant on call. However, Mr.
S. Hussain, on behalf of AT Sarkar.
On behalf of
AT Sarkar.
Mr. Hussain, Learned Counsel. On behalf of Mr. A.T. Sarkar, Learned Counsel for the respondents present. List the matter on 30th of September.
All right. Item 18. May it please your lordship. My lord,
This is arbitration appeal.
lordships. Lordships, this arbitral amount lordships, that is 49 lordships. 49 lordships. Passed by the arbitrator lordships. Paragraph 19 lordships.
Yes.
In the result, award is made as follows. The respondent shall pay an amount of rupees 11,64,600 to the claimants together with interest thereon at the rate of 6% per annum from 17/6/2008 till the date of actual payment. The respondent shall also pay an amount of rupees 16,100 to the claimants on account of their unpaid share of fees and expenses as indicated in para 18 above. 3. It is declared that the termination of the contract as made by the respondent's letter dated 31/1/2005 is illegal and void. 4. It is declared that the memoranda dated 10/6/2005 and so also the memoranda dated 25/11/2005 are illegal, inoperative. Lordships, against that lordships, we have approached before the learned district judge lordships, and this learned district judge pays 60 lordships. Page 60, paragraph 18. In view of what has been discussed herein above, the petition under section 34 of the Arbitration and Conciliation Act is dismissed. Lordship, against these lordships, we have approached before this honorable court law. Now, lordships, in respect of paragraph page 49 lordships, in respect of that principal amount, that is amount without interest, 11,64,600 and 11,100. That lordships we are ready to pay, but we dispute against the interest part lordships. Now lordships, this
Why this amount was awarded in the year 2011? And the interest for interest rate of interest is also only 6%.
Lordships, when contract was given, Lordships, it was a condition precedent that there should not be no interest is to be paid, Lordship. Lordship, in respect of that, Lordships, I will place before this honorable court, Lordship, this judgment, Lordships. Lordships, this is the Honorable Apex Court judgment, Lordships.
Which is the relevant paragraph?
Lordship pays, Lordships, paragraph 13, Lordships, 1-3.
Which judgment?
Lordships, Union of India versus Mondras Enterprises.
Yes.
Mondras
Paragraph
en-
number?
Paragraph 13(1)(3), Lordships. In view of the aforesaid discussion and for the reasons stated above, we hold that the learned arbitrator in the instant case has erred in awarding pendency light and future interest on the amount due and payable to the contractor under the contract in question, and the same has been erroneously confirmed by the High Court. Lordships. Lordships, then Lordships, this when contract was offered, Lordships, at that time, there was a condition precedent, Lordships. That is GCC, General Conditions of Contract, Lordships. Lordships, here Lordships, see, Lordships, page 22, Lordships.
22 of
22, Lordship, that is the original one, Lordships. Engineering Department works
of the appeal.
Lordship, General GCC, General
Page
Conditions of
number,
Contract.
page number.
Paragraph, Lordships, page 22, paragraph 16(1).
22 of which
Lordships, Contract Engineering Department.
no, you have given the copy to me
Lordships,
here. NF Railway.
page 22, paragraph 16(1). 16(1), earnest money and security deposit. That
Page number
page 22, paragraph 16(1).
16 yes. Earnest money and deposit.
Lordships, earnest
Security
money
deposit.
and security deposit. The earnest money deposited by the contractor in the tender will be retained by the railways as part of security for the due and faithful fulfillment to the contract by the contractor. The balance to make up the security deposit, the rates for which are given below may be deposited by the contractor in cash or in the form of government securities, or may be recovered by percentage deduction from the contractors on account of bills provided also that in case of defaulting contract, the railway may retain any amount due for payment. The contractor on the pending on account of bills, so that the amount so retained may not exceed 10% of the total value of the contract. Now, lordships, here general conditions of contract, and next page, lordships, page 23, lordships, 16.3, lordships, next page, page 23, 16.3, lordships. No interest will be payable upon the earnest money and security deposit or amounts payable to the contractor under the contract, but government securities deposited in terms of subclause 1 of this clause will be payable with interest accrued thereon. Lordship, this is the original contract, and lordship, subsequently there was lordships amendments also, lordships. In the amendment event, lordships, in the amendment also, lordships, that is amended on 27/4/22, lordships. 27/4/22, lordships. Here, lordships, page 48, lordships. Page 48. Subsequent amendment, 27/4/22. Page 48, clause 16.3, lordships.
Page 48.
48.
48 is a certificate of fitness.
Lordships,
Clause 60.
clause 16.3.
In the same general condition of contract.
Lordships. Indian Railway Standard General Conditions of Contract.
Page number.
Page 48, lordships.
48. 48 is a certificate of fitness.
Lordship, I have supplied a new one.
Itu নেই। itu তো 48 তো নহয়। কোথা আছে? itu 48 itu। Yes.
Lordships, here, 16.3. No interest shall be payable upon the bid security and security deposit or amounts payable to the contractor under the contract, but government securities deposited in terms of subclause 16.4 B of this clause will be payable with interest accrued thereon. Lordships, no interest shall be payable upon the bid security and security deposit. Lordship, that amount, that is 11 lakhs
No,
plus.
the amount awarded by the arbitral tribunal, the arbitrator,
Lordship.
it is security deposit.
Lordships.
There's a 11 lakhs.
Lordship, it is calculated because this one, their claim is, lordship, that is in appeal.
There's a page number 49.
49, lordship.
Yes.
Lordship,
There's 11,64,600. It is the bid security.
Lordships, page 20, lordships. Page 20 of appeal, lordships. Page 20 of appeal.
Yes.
Lordships 3.5.
Mm.
On the basis of aforesaid facts, that's the claimants make the following claims. These are the claims amount.
Mm.
One, payment of final bill, 1,50,000. Refund of SD, 3 lakhs. Compensation for illegal blockade of bill, 18% from the date of works done. Compensation at the rate of 15% on leftover work, 10 lakh 6,720. Interest at the rate of 18% per annum from the date of termination of the contract till payment, 14 lakh 56,000. Then Lordship, another two are there, declaration to the effect and declaration to the effect that the memoranda issued for recovery of 8 lakh 46,440.
Where?
7, serial number 7.
Serial number 7.
7, 3.5 Lordship, page 20,
Page 20.
Lordships.
Oh, yes.
Declaration to the effect that the memoranda issued for recovery of rupees 8,46,440, 8,48,940, and 9,90,550 are illegal and void. Now, see, Lordship, these are the claim amount by the claimant Lordship. And this arbitrator has calculated and accordingly Lordships, this award is made Lordship. Page 49, paragraph 19 Lordships. 11,64,600
Mm.
and 16,100. 11,64,600.
Mm.
There is interest with effect from 17/6/2008. And in regard to 16,100, there is no interest mentioned. Lordships, this amount Lordships, 11,64,600
Mm.
and 16,100, this amount Lordships will pay, but not interest Lordships. Because Honorable Supreme Court also says no
Mm.
interest to be paid, and also there is a condition
Mm.
when the contract was signed between the parties. At that time, the contractor took the undertaking that no interest will claim it, Lordships. And this is my humble submission, Lordships. And Lordships, one additional affidavit I have also filed. Additional affidavit I have filed on 7/6/2017.
Yes, who is for the respondent?
Yes, my lord, I have heard it.
You for railway.
I am for the
Oh, sorry.
claimant.
Oh, yes. That's Arden Sodori. Yes.
My lord, I fail to understand from which GCC he is reading, because he has not referred in his memo of appeal.
Mr. Sharma, whether this document was placed before the arbitrator and also before the district judge?
No such documents were known.
This document, this is GCC, General Condition of Contract.
Lordship, this when contract was awarded, both the parties signed and one copy was given to the contractor also, Lordships. And contractor knew it that these are the conditions, Lordships. And that all conditions and even the new condition I have placed before this honorable court. In all condition also, it is clearly says that there is no interest part. And the
No, whether these were brought to the notice of the arbitrator as well as the appellate court. No, as well as the session judge, no, district judge.
Whether such statements were made in their pleading or not, main question.
Yes,
And second question, your lordship may kindly come to page 17
of the
of the
appeal, page 17, yes,
paragraph 3.2.
yes.
In the meantime, on 5/6/2020, the contract agreement was executed for the performance of the aforesaid work set forth in the schedule thereof under general condition of contract and the specification of NF Railway 1993 edition. This was applicable in our case. And the ground of appeal, my learned brother is in the ground of appeal made some other statement. Your lordship may kindly come to page 8. And he is arguing on some other aspect. Page 8, paragraph 9. For that, page 8.
Page 8 of the appeal memo.
Yes, my lord. Ground number 9, my lord. For that, the learned district judge failed to consider that while passing the award, the arbitrator was in contravention of clause 62(2). It is not relating to, he is arguing on 16. Clause 64(5) of GCC 1998. Now GCC 1993 is applicable. And he is making the submission on the basis of subsequent GCC, which is not applicable in my case. Because 64(5) is not available in the earlier GCC, which I have one copy is with me, my lord. He has been wrongly instructed, my lord. This GCC applicable, in this GCC 64.4 is not applicable, not available. So this is their ground.
No, this you were referring to page number.
Page number, my lord, this page number 17. This is award, part of the award.
Page number 17 is a different.
In my memo of appeal, page number 17, part of the award is there.
Here, page number 17 comprises of this point number 3.2 and 3.3.
Yes, my lord. In 3.2, it is observed, my lord. In the meantime, on 5/6/2022, the contract agreement was executed for performance of the aforesaid work set forth in the schedule thereof under the general conditions of contract GCC and the specification of NF Railway 1993 edition. It is a contract, it is a part of the contract. New edition, it is not a law that he will bring the new edition of the GCC in that case. And at this stage,
1993 edition.
Yes.
This is 1998 edition.
Yes, this is not applicable in my case. 93 is applicable. In 93, 64,
Yes,
4 is
Mr.
not there.
Soma.
And his ground is 64.5.
Lordships, in certificate lordships, page 12 lordships. In certificate, I have clearly mentioned. Certificate lordships.
Page number?
Page 12 lordships. 12 of appeal. And also pray.
Where you have placed it?
Page appeal lordships.
Page number?
12. In certificate, also pray for the right to take additional connected grounds at the time of hearing of this appeal, Lordships, whatever connected grounds are there, latest grounds are there.
No, Mr. Sharma, it is plain and simple that at the time of contract, it is specifically mentioned that the GCC and the specification of NF Railway 1993 edition shall be applicable.
Yes.
Then how can you make this 1998 edition applicable to the contract that was entered into
2002.
2002?
Lordship, this Honorable Supreme Court Lordships, this is the latest judgment, Lordships, and this is the, as per these Lordships,
No, forget about that judgment. How it can be applicable? You show it first. And whether those conditions are there in the edition on 1993. The counsel for the respondent submitted that it is not
64,
there.
5 is not available here. And 62 is, 63 is not relating to interest. This is relating to arbitration. 17B is relating to extension penalty. He cannot travel beyond his ground.
Definitely. Definitely.
And only he is challenging the interest part. So I am confining only on the interest part.
Lordships, in respect.
You, let us do one thing. We will postpone it. In the meantime, you obtain instruction.
Lordships.
Huh? And also you produce a copy of the 1993 edition before this court.
Yes.
Hmm. Or Mr. R. Sharma, learned counsel for the appellant, and Mr.
R. Hussain.
R. Hussain, learned counsel for the respondent. Heard in part, list the matter. So do we fix a date?
Lordships.
When?
Second week of September.
Second week of September.
Last part of September.
Last.
As part heard. Any other matters?
24, my lord.
21.
24 September, my lord.
He will furnish a date.
21.
May it please your lordship.
Hmm.
Lordship, I am for the appellant.
Hmm. Who is for the respondent?
Lordship, the respondent counsel, Mr. H. Gupta, is there, lordship. How can I find out? Lordship, basically, we are challenging the impugned judgment in order dated 19/6/2019. Lordship, passed by the Railway Claims Tribunal Guwahati bench in the original application number 86 of 2009, which Lordship will find at page 10, Lordship. In this case, Lordship, basically, Lordship, the
Let the council come. Okay.
Lord, they've inquired from the department, Lord, it is not a covered matter. Lord, my lord, we'll take it, Lord, some other day. On the last occasion, my lord, they have produced some judgment saying that that judgment is covered by, the present case covers by that judgment. Lord, we have consulted with the department. Lord,
as per last order dated Lordship 19/6/2024, Lordship, we have submitted that Lordship, the issue is covered by the judgment of a coordinate bench. So Lordship, the learned counsel for the respondent.
Where is that judgment?
That judgment is Lordship. Basically, Lordship, the issue is with regard to the refund of terminal charges. In this case, my lord, the council, the respondent, that is Railway Lordship, they have levied terminal charges at the point of originating station, Lordship. So this terminal charges, it's not applicable in our case because the station against which they have charges, my lord, that terminal stations is not under the list of the selected notified stations, Lordship, as per the circular dated 5/6/2007. And on the basis of that circular, Lordship, the coordinate bench passed this judgment, Lordship, in MFA number 45, 42 of 2015, 2017. So, Lordship, in this case, the Honorable Court held that paragraph 10, my lord. Paragraph 10. That regarding the second question, there is no quarrel with the proposition that there are 50 specific stations having all the infrastructures for loading and unloading of goods. And if any of those 50 stations are used, then only the railways can charge terminal charges. For other stations, railways cannot levy terminal charges. The railway has to refund the terminal charge. In the present case, Lordship, both the stations do not fall under the list of 50 stations. So this is my case, Lordship. I will properly explain before you, Lordship. If the council ask for some time, Lordship, to make their submissions, then Lordship can fix the matter on some other day, Lordship. We will make our submissions more elaborately, Lordship, because there are number of circulars also, Lordship, will need to examine, Lordship.
Yes, sir, Mr. Gupta.
My lord, if they want time, my lord, in the
I need
WS,
some time because now,
in the
Lordship.
WS, my lord, we have categorically stated that no, these are terminal stations, my lord. So in the records, my lord, at page 61, so, my lord, in the LCR, my lord, will see at our WS, which we have filed before the RCT, my lord. My lord, my lord, it is flag marked, my lord, will see in the top WS in the LCR, my lord. Orange color.
Yes.
My lord, in the WS, my lord, paragraph 9.
Yes.
Second paragraph, my lord, paragraph 9, second paragraph. Further, the respondent Central Railway Administration submits that GRMT Goods Shed and New Guwahati Goods Shed are terminal stations. The applicant has misconceived and misunderstood the concept of terminal stations. It is submitted that every goods shed where loading and unloading operations are carried out are the terminal stations. Though in general terms, it is called a goods shed. As such, the applicants are not entitled to refund of terminal charges collected by the railway administration. And further, my lord, at page 14 of the present, my lord, petition, present MFA file, my lord, page 13, when, my lord,
Of the present petition?
Yes, my lord, page 14, my lord. My lord, the learned RCT, my lord, while dealing with the issue in question at paragraph 13, my lord, page 14 of the petition, my lord, paragraph 13 of the impugned judgment. My lord, the tribunal had on the issue, my lord, tribunal had relied on the full bench, my lord, division bench decision in OA number 23/2000.
Page number?
Page number 14, my lord.
Yes.
Paragraph 13. Now, whether the respondent is justified in levying terminal charges. This is the issue which is specifically put to challenge, my lord. As regards terminal charges to be recovered in bagged consignment, without dwelling into the detailed reasoning, the decision by the division bench taken in OA number 23 of 2010 in the case of Messrs. Purvanchal Cement Limited and OA number 119 of 2008 in case of Mahashakti Cements by the division bench is directly applied in the instance case wherein it is clarified that terminal charges were due and correctly recovered from the claimants. As such, the claim for refund of terminal charges is not allowed. The respondent is justified. My lord, this judgment, my lord, learned friend, my petitioner has not annexed, my lord, with the petition. My lord, basing on a division bench judgment of the own, my lord, RCT, my lord, the claim was allowed. And so far as the claim whether they fall under terminal station or not, my lord, the WS we have categorically mentioned that they fall within the list terminal stations, my lord, and therefore the charges were rightly levied.
Lordship, in this case, Lordship may kindly peruse our claim application, which was filed before the Railway Claims Tribunal. There we have categorically mentioned that the booking station is Karad and Karimganj. And in the WS, they have mentioned that it is GRMT Goodshed and New Guwahati Shed. This is not a case. This is not our case, Lordship. It is wrongly mentioned in their WS at paragraph 9, Lordship. I don't know where they have found this station, Lordship. In the claim
So this,
application, claim application is at page 53. It starts from 53 of the LCR, Lordship. $53.
okay. Claim application. Page number?
53. It starts from page 53, Lordship.
53. Yes.
And on the next page, Lordship, the particulars of the claim is there, Lordship. Paragraph 5, full booking particulars of the consignment.
Claim petition. You show it from the record. The pagination are in backward
Lordship, in
mode.
the trial court, the counsel who is engaged there, Lordship, he must say. Backward.
Yes.
Away. Itu first itu
The claim application was prepared, Lordship, on the basis of the format, Lordship. And in this application, Lordship, at paragraph 5, Lordship, the particulars of the consignment was there, Lordship. It was date of booking was 2/10/2008 under invoice number such and such from KRD. KRD stands for Karad, Lordship. It is in, it falls under Central Railway, and the destination is KXZ. KXJ is stands for, Lordship, Karimganj. And another consignment which was booked on the similar date, and again it was booked from Karad to Silchar. So these two stations are there, Lordship. And on the next page at paragraph D Roman 2, Lordship, we have categorically stated that total such and such packaged sugar booked in this transaction from such and such to Karimganj and Silchar goods, which are regular goods booking and delivery station known as goods sheds, managed and controlled by railway for over the last 20 years. And these stations, Karad and Karimganj and Silchar, were never statutorily notified by railway as the terminal stations. And as such, railway collections of excess freight money on account of terminal charges are not applicable in this case, and hence we demand and claim for the refund of the same. Now, Lordship, in their WS, at paragraph 9, they have mentioned about some other stations that further respondent Central Railway Administration submits that GRMT Goods Shed and New Guwahati Goods Sheds are terminal stations. So this is not the case, Lordship. They have wrongly submitted, Lordship. Our stations falls
Mr.
under
Gupta?
different categories.
No, my lord,
Have you
in fact,
cited?
no, my lord, this is not correct, my lord. In fact, my lord, the petitioner before your lordship, my lord, he is neither the consignor nor the consignee.
That is not the
My lord,
dispute,
he is
Lordship.
the endorsee, my lord. In the railway, my lord, it is only the liability of the railway is only between the consignor and consignee. My lord, will see the WS which we have filed, paragraph 1. No, we have,
Lordship, this is not the issue before
we
us.
are not the
before
consignor or
Lordship.
consignee, my lord. My lord, will see paragraph 1 of our
It's our appeal, so it is-
WS.
They cannot plea, Lordship, this plea cannot be raised at this stage because this is our appeal. We have preferred this appeal against the levy of terminal charges, Lordship. Now the question
Correct.
before your Lordship is whether this terminal charges is applicable or not, Lordship. So
But being
as
an
we have,
endorsee, my lord, they cannot raise the issue.
Lordship,
It
endorsee
is
has
only
the
a
title in
consignor
terms
or
of
the
section
consignee.
74 of the Act, Lordship. Lordship may kindly peruse section 74
74
of the Railway Act 1989. Since the question with regard to the locus standi of the claimant is there, Lordship, now Lordship needs to understand what is section 74, Lordship. Lordship, section 74. Got it, Lordship?
Yes.
Section 74, passing of property in the goods covered by railway receipt. The property in the consignment covered by a railway receipt shall pass to the consignee or the endorsee, as the case may be, on the delivery of such railway receipt to him, and he shall have all the rights and liabilities of the consignor. Now, the submission that the learned counsel for the respondent is submitted, has submitted now, Lordship, is saying that endorsee has no right to claim for levy of terminal charges, Lordship. Now, the section 74, if Lordship see, Lordship, endorsee has the rights and liabilities of the consignor. So he can prefer claim before the claims tribunal. And this is not the issue, Lordship. The issue is only whether this levy of terminal charges is correct, legal, or Lordship, in terms of the circular passed by the railway board, as well as the judgments passed by this honorable court, Lordship. This is the main question, Lordship. So the judgment.
Yes, Mr. Gupta?
My lord. My lord, in paragraph 7, my lord, will see the fact which my learned friend is saying that my lord,
Paragraph 7 of?
paragraph 7, my lord, page 12 of the petition, my lord. Page 12, paragraph 7.
Yes.
My lord, as per the claim application, the notice under section 106 was issued on 15/12/2008 in by the engaged counsel, and the application was signed by the authorized signatory of Messrs. PP Enterprise. Respondent admitted the receipt of notice, however, its validity and legality under section 106(3) of the Railway Act 89 is denied by stating that Messrs. PP Enterprise is neither consignor nor consignee and did not have a letter of authority from the consignee Messrs. Garden Courts Distilleries Private Limited, Mumbai at Kolhapur. Not he was the original consignee. Further, it is submitted that Messrs. Garden Courts Distilleries Private Limited have served notice on dated 2/1/19 was received on 9/1/2009, and refund of overcharge of rupees 26,406 was arranged to Messrs. Garden Court Distilleries Private Limited wide check number dated 2/3/2009. Hence, the cases are liable to be dismissed. On perusal of the RR, it is also found that Messrs. PP Enterprise was made endorsee and goods were delivered to PP Enterprise. So,
That-
my lord, in respect of the, my lord, excess freight charges, the amount, certain amounts were, my lord, found excess recovered, that was already paid to the original consignee. Now, being an endorsee, my lord, the petition is filed saying that the charges were wrongly levied. They have no locus standi to file, my lord.
Lordship, may kindly
The
see
amount in
paragraph
fact
8
was
also.
originally paid to the consignee.
He is not reading the entire paragraph, Lordship. He's
It is
reading the
admitted
only
fact that, my
paragraph
lord,
7.
the certain amounts which were liable to be refunded, that was refunded by the railways to the original consignee. Now today, my lord, if they are claiming that they have been charged excess, my lord, tomorrow, my lord, the original consignee will come again make the second claim. Now that is not permissible, my lord. They been just the endorsee of the goods. They are not entitled to
No,
object.
whether you have raised that issue before the
Yes, my lord, this is
tribunal.
in paragraph 7 which I have read. My lord, the observations are apparent. Tribunal has made an observation. Paragraph 8 also, my lord, the perusal of RR also reveals that Messrs. PP Enterprise was made endorsee by Messrs. Garden Court Distillery Private Limited and delivery of goods were taken by PP Enterprise. Original consignee has to raise the claim, not the endorsee, my lord. Here the endorsee is coming before the court. That would, my lord, lead to making two claims, my lord. If such a claim is allowed to the petitioner who has no locus to file the petition, tomorrow, my lord, the original consignee will again claim to the before the railway.
So you come prepared with instruction of whether those two stations are terminal stations or not.
Yes, that I will, my lord, take instruction. my lord.
So as agreed by learned advocates of both the parties, it is to leave the matter on probation.
19th September.
19th September.
I'll take specifically.
I don't know, one active, but there is some urgency in the matter, my lord, after today, the time does not permit, my lord. It can be, my lord, my learned friend agrees, my lord, then it can be fixed on 6th, my lord.
I think number
When?
6th.
20.
6th, September, my lord.
6th September.
Already a lot of cases have been fixed in the first week of September. So
After 6th, any date, whichever 6th or before. 6th, we can do it on 10th is Tuesday.
Tuesday,
10th of September.
10th of September, okay. Tuesday,
Tuesday, my lord.
okay. Okay, we'll try, but we cannot take the risk that your matter will reach on that day.
No problem. And there is an interim order which will continue.
Okay.
Lordship,
As agreed by learned advocates of both sides, SSL is the matter on 10th of September. 10th of September. Till then, interim order pass earlier shall continue.
Manoj, I have a request, Manoj. Manoj, I have a request, Manoj. I come from Delhi for this matter. This matter was specifically fixed. Manoj, subject to your lordship's convenience. Manoj, I am still here on Tuesday or Wednesday if your lordship have, because Manoj, there is also, because Manoj, there's an interim order which was granted on 12th of June. We approached the Supreme Court. Supreme Court said have it expeditiously. Your lordship fixed it expeditiously, Manoj. Now, Manoj, 1st of September, Manoj, I come here specifically for this matter. Manoj, I'm here again on Tuesday or Wednesday whenever it's subject to your lordship's convenience. Your lordship could have
Tuesday
it.
will not be possible.
Then Wednesday have it. Manoj, on Wednesday.
Thursday will be. Thursday.
My learned friend, every time, then if the stay is vacated, then my learned friend will not be in
No,
difficulty.
that's not that.
No, Manoj.
And you said the Supreme Court has not entertained your writ petition, your petition SLP.
It has said,
Oh, yes.
I had
not
that order
entertained.
was read out to your lordship
Yes.
for the last week. Manoj, and Manoj,
Not
it's a
entertained.
reasonable, it was
Yes.
disposed of, it was not dismissed, and it has made observations that it has to be discussed.
One day.
My only
I'm
request,
asking-
Manoj, since your lord, it was not that I'm pressurizing your lordship in any manner, it was subject to your lordship's convenience that this matter was fixed today. And Manoj, now I'm only requesting if it could be had on Tuesday or Wednesday.
Tuesday not possible, it will be Thursday, there is absolutely no problem.
Very well, Thursday, Manoj.
Thursday. let it
Thursday,
be
if I may
Thursday.
request, Manoj, for a specific time at 12 o'clock or something.
Thursday.
Thursday, then I can leave by the evening flight, Manoj, if your lordship. 12 o'clock.
We'll mention 29th.
We'll mention it at 10:30, but if your lord, I would request your lordship to have it in the first part.
29th.
29.
29th.
Okay, we'll try.
Yes.
I'm staying back for that one. That's my only request.
Well,
to the
only
lordship.
interim order that will continue.
Already dictated.
Lordship, item number 23, Lordship.
Take a date from him.
10th,
Other
10th of
matters.
December.
Okay.
I'm good.